Extension upon notice. Mentioning is not being taken now, sir. Please wait for mentioning is the. Please see the first page of my list. You have to wait for some time. Mention, yes. Please see the first page of my list. I'm not taking up mentionings now. You have to wait for some time, please.
My lord, the humble submission before your lordship. This matter is relating to Circuit Bench Jalpaiguri contempt applications of your lordship's order, lordship.
Appearing for the first time?
At first time. I'm grateful.
An upgradation matter, your lordship.
Please see the first page of my list before you mention.
Restoration application, my lord. Restoration application.
Upon notice?
Lordship, it's an upgradation matter. If the matter not be upgraded, then the application will be infractuous.
Why?
Lordship, this is a khal, and khal is filled by the private respondents, and the khal is used for the cultivation purpose, and the farmers are suffering, my lord.
Please wait for some time.
Lordship, one accusation matter, your lordship, if the matter is not heard urgently, the petitioner will suffer irreparable loss.
Don't you think petitioners are suffering in all the matters which are before this court? Before any court for that matter? Please wait for some time. Call the raised list, please.
I took one.
Correction method. Then to the এই লাইনটা ডিলিট করে দিচ্ছি। Inadvertent error has crept into the order passed on May 11, 2023. The second line, the second paragraph of the order, inverted comma open korun, written instructions submitted on behalf of the petitioner is taken on record, inverted comma closed, be deleted. Paragraph, the department is directed to incorporate necessary correction accordingly. Paragraph, this order be treated as part of the order passed on May 11, 2023. Urgent certified website. Next.
Well, I'm for the petitioner. Well, I'm praying for correction of the cause title.
Correction of the cause title?
My lord.
What is the mistake in the cause title?
My lord, the actual cause title is Gopinath and others. But in the order dated 15th May 2023, the order passed with a cause title of Kailash Rana and others. My lord, I'm praying for correction the cause title as per the writ petition's cause title, madam. হবে wrong আছে গোপীনাথ হবে কৈলাশ রানা হচ্ছে
It should be Kailash Rana.
My lord.
Inadvertent error has crept into the order passed on কোথা থেকে নামগুলো পায়? Passed on 15th May 2023. Rajiv will go. Paragraph in the cause title of the order, Gopinath Mondol and others, and another, Gopinath Mondol and another be replaced by, be read as Kailash Rana. Paragraph, the department is directed to incorporate necessary correction accordingly. Paragraph, this order be treated as part of the order passed on 15th May 2023. Urgent certified website.
3 and 4, my lord, I am appearing. These are restoration matters. My lord, it got dismissed by.
Have you served the other side?
Yes, my lord, we have served. Here is the affidavit of service.
Is it within time?
It is within time, my lord. And
Yes, Mr. Butterfly.
If you have, my lord, this is,
Can we deal with the writ petition now?
yes, my lord, yes, yes,
Yes, sir.
yes.
Yes,
Yes.
yes, let it be allowed, my lord, and fix the date of hearing of it, please.
Fix a date for hearing of
Well,
the
only there, I am just bringing this to your lordship's kind notice, my lord,
Yes.
that if the order sheets will reveal, my lord, so Junior also brought the last order, my lord. The government has been very categorical that the money has also been allotted. I mean, I am using the word
The compensation.
compensation. Now, my lord, every time the government has sought time, and the last order is a speaking order that the government will come with instruction for release of the money. Now that instruction, my lord, they have had a year or 2 years or something. My lord, I have lost count of it. Now, last occasion I pressed for and said that I want to see the color of money now because my land has been taken.
Have you filed a representation before the authority
No, my lord, that
for payment of compensation?
yes, my lord, that is the compensation. That is why, my lord, I am in court because I want the compensation.
No, no. Have you filed an application before the authority
No, my
in
lord,
this regard?
no, my lord.
So why don't you approach the authority? Let them dispose it of within a limited period of time.
No, my lord, that is there. All that is there. Everything is over, my lord. I've made a complete chronological pleading of it in the petition. Now, my lord, the only question now arises that the effect of section 24 under the new.
Has the authority disposed of your representation?
No, my lord, there is no representation, but my lord, there are responses where the authority says, my lord, that they have allocated the fund, it is waiting for disposal.
Let the state come back with a report in that case.
My lord, yes.
Yes.
Report has also come, my lord. I have been
Oh,
told.
report is on record?
Report is also there. My lord, everything
Shall we
is
fix a date?
there.
Let him, he is not ready today. Let him come back on it. with
My lord, if
instruction.
my there, my lord, kindly, my lord, Tara. My lord, kindly, my lord, this matter will get disposed of, my lord. If you kindly, my lord, fix a date and
I will.
I'm deep your any thing that is convenient to the
Can 2 of 2024.
date and time.
This is an application for restoration of the writ petition which was dismissed for default by an order passed on 5th February 2024. Paragraph sufficient grounds being made out, comma, the application is allowed. Paragraph, the order passed on 5th February 2024 is set aside. Paragraph, the writ petition being WPS such and such is restored to its original file and number. There shall, however, be no arrest costs. Can such and such is disposed of. WPA the order for it. Let the matter appear under the heading Group 1 motion on 16th April.
My lord. My lord, may
Affidavit of
I seek
service.
one more indulgence, my lord?
Yes.
Whatever comments, if your lordship kindly indicates the time if possible.
That's not possible in this court.
2 p.m. perhaps, my lord?
No, it's in the first half.
First half.
Group 1 matters are taken up in the first.
The first half. Very well. No, I'm sorry.
Please come.
I'm sorry. My lord, very well.
For it
My
to
lord,
take it into the- I'll just call the next man.
my lord. Same, my lord. Same order. Same.
The order passed on 5th February. Same.
Same.
The same order is being
Same. And my lord, no order is required, but it is understandable the lordship's officers will put it in some place where it will be hard. My lord.
Let us see.
I'm deep here.
That's
I'm
difficult in this court. Let us
I'm
see.
deep here. I'm deep here.
Item number 5, pursuant to an order passed by Honorable Justice Shivakant Prasad, as his lordship then was, I was appointed the special officer in this matter. My lord, unfortunately, my lord, I was not put on notice that the matter will be appearing today. I had the report is ready with me, but I was beseeching your lordship so that it can stand over for a day so that I can file a report on the next day.
What was the direction on you?
My lord, I was directed, my lord, to go to the locale and inspect the locale insofar as the illegal demolition that was alleged by the writ petitioner of their dilapidated house, my lord. And I had visited that locale, my lord, taken the testimonials, photographs, everything is done, my lord. It is there in my file, my lord.
It's appearing for the petition. You're the petitioner? What about the respondent?
But there are
know what report my friend has given.
He has not.
no, my lord. It is there with me.
Let me submit the report. Now, today, my lord, your
Yes,
lordship,
yes.
And my lord,
you asked me that whether the limitation of this, in the meantime, the petitioner died. My substitute petition made, your lordship, or the limitation is 3 years, my lord. I have within 2 years, I have filed the restitution.
Limitation is 3 years.
Yes, petitioner died. Her son, husband, and daughter want to substitute. Substitute petition I have filed. Your lordship said that it may be time, but what the
How can the limitation be 3 years?
3 years,
Please show me. Substitution limitation 3 years?
87, yes. 80.
It's 90 and 50.
Item 87, and I have also prayed for compensation in this matter.
This is for compensation for trespass,
I
not
have paid for-
substitution.
Yes, I have prayed for compensation. I have,
I'm afraid the writ petition has abated.
Lord,
The writ petition has abated
my
because
lord,
the sole
it has
petitioner
not
has
been
died.
abated, my lord. My petition is that they have forcibly entered their damage. I prayed for
Maybe, but you should have substituted within the statutory period of time.
a subsequent 3 years, my lord, and filed application to
This
the
is not substitution, sir. 3 years, you're aware of Order 22.
According to my lord, the Limitation Act, your lordship said in this case. it is-
Limitation Act for payment of, this is for compensation.
Yes, I
So
pray,
the original writ petitioner had asked for compensation.
yes.
He has expired, so you're guided by the Code of Civil Procedure now and not this. What is the limitation for substitution according to the civil procedure? 3 years?
But in this case, my lord, I find it is.
What does this say, sir? Please go through this.
Since the
It's for an application for compensation which is already there. You're asking for substitution after the suit, after the case is abated.
But, my lord, I think they are-
You have to file an application for setting aside of abatement. That's Order 22 Rule 9, I think, isn't it?
my lord,
But it's a minor matter, my lord,
I have to dismiss as are abated, as it has abated. I cannot help you in this matter.
it's seriously not the limitation in this matter.
3 years limitation for substitution, sir.
Yes, it's
For substitution, where is the language? Please show me. 3 years is for compensation
compensation and also, Lord,
and also substitution. Where is the language? Please show me, sir. I would like to learn. Didi boita diye din tonake.
since the matter was taken up, my lord, thereafter the matter did not appear. So, my lord, I was ready with the report, but unfortunately, since the matter was not listed, I could not have filed.
Issue altogether now.
Yes,
You are repeating-
absolutely.
Yes.
Lord, it is said, my lord, the compensation for trespass our movable property. Therefore,
You are asking for substitution, not compensation. You say that the original writ petitioner has expired during pendency of the writ petition.
Yes.
You have not substituted his legal heirs within the statutory period of time, and the writ petition has abated. So that will be exactly the order that will pass today.
Setting aside chance.
Lord, then
Application.
see one condition. If it is so, if without taking I am the at the substitution, but when the petitioner died, I am the actual inheritor. I may come forward.
Yes, the law has given you the liberty to come forward within a stipulated period of time, which you have missed.
No, a period time.
Sir, I don't think we should spend more time on this now.
Setting aside an application করুন না setting aside an application করুন হবে
Lord, I may be liberty to give the application for this limited repair for condemnation. Application may be filed.
till such time the writ petition is my lord, restored, my lord, do I file the report?
Let him file his application, he should justify his claim. Otherwise, it abates.
Till such time the writ petition is restored, my lord, I shall be keeping the
It appears that the writ petitioner is the sole writ petitioner, isn't it? Expired on 6th April 2021. Stop. His legal heirs, her legal heirs have not been, her legal heirs have not been substituted till date. Stop. The writ petition has abated. Paragraph learned counsel for the petitioner seeks to take appropriate steps in this regard. Paragraph, let the matter go out of list for the time being. Liberty to mention.
do I, my lord, give my name to the that's I am appearing grateful, my lord.
Yes.
Restoration.
Restoration.
I have served the notice
Sir,
to all the parties.
Copies of.
I'm for the state.
No objection, I'm sure.
No objection.
I have served all my lord endorsement.
Can we deal with the writ petition now?
My lord,
Can we deal with the writ petition now?
Just now.
Just now? No. Yes, are the respondents ready? No. Can 2 of 2024 within time?
Within time.
On 5th February, it was dismissed. On 28th February, I have filed.
This is an
Within
application
13
for restoration of the writ petition which was dismissed for default by an order passed on 5th February 2024. Affidavit of service level children. Paragraph, sufficient grounds being made out, comma, the application is allowed. Paragraph, the order passed on 5th February 2024 is set aside. Paragraph, the writ petition being WPS such and such is restored to its original file and number. Paragraph, there shall however be no arrears to costs. Paragraph, can such and such is disposed of. WPA the order for let the matter appear under the heading Group 1 motion. Motion.
No, actually it was appearing under the heading hearing.
Affidavits are complete.
Yeah, affidavit direction was there. Your Lordship kindly see earlier direction was there, but they have not, they choose not to file. On 9th March, well, there is a direction for filing affidavit. No affidavit has been filed.
Opposition has been filed.
Right.
Opposition has been filed. You need to file an exception to a reply to it.
Already filed, my lord.
Yes, yes. Reply.
Exception not yet.
Not yet filed. Learned counsel for the learned counsel for the petitioner seeks extension of time to file an affidavit in reply to the affidavits in opposition submitted by the respondents. Paragraph, let the matter appear under the heading Group 1 hearing on 1st May.
1st May.
1st May.
No case.
Please exchange your affidavits in the meantime.
Yes, yes.
Next.
Item 7.
I am appearing for the contempt and the applicant in the can 1.
What is plan 1?
That is one of the modification of my lord's order. Just I have received the affidavit in opposition. Only one thing in application that kindly see in the prior portion inadvertently that has been stated modification and dot setting aside. If my lord find the preamble, that is the mistake due to copy paste. An application, preamble and application for clarification and modification of the order dated such and such. And in the body also I have prayed for, kindly see in the paragraph, the paragraph 15, unless the order dated such and such is the modified. But in the prior portion, due to the modified and not to be set aside, that portion I am praying leave to correct. That is
Paragraph 15 says direction in terms of prayer A of the writ petition
is modified. I never prayed for setting aside. For modification on the ground.
to sit in appeal over the order.
No, my lord. I am praying for modification on that ground. In the prior portion, wrongly the mention modify and or to set aside. That should be I am praying leave correct the prior portion. This portion and or to be set aside should be deleted. Other
Not only that, my lord, what modification is asking for, that has not been proposed. What is asking for? What modification, my lord? And after long one years after, when contempt application has arisen, thereafter it comes with a fresh brain.
Yes,
to-
what is the modification that you are asking for?
My lords, the modification, in they wanted to the gifted 3 plots of land. My lord's order was allow the repetition in terms of PRA. PRA talks about.
It is that matter, yes.
Yes, talks about the annexed P1. At the process of compliance, for the execution of the gift deed, we find the in one plot is one water body is there, and in one plot the recorded Borgadi is not yet corrected, and another plot is unlocked. We also communicated the petitioner to the 2 lands whether he is interested to give this land for gift or not. That reply also not come. So for this purpose and another thing, this is the co-sharer land. co-sharer land, which portion they belongs to the petitioner.
You have stated that it is required to be modified. What is the modification necessary? You have not stated.
Since he the suppress, the
Where is that stated in your application?
This is my affidavit, Dinto. This is my reply.
paragraph 8, what I have stated, your applicant says in response to the letter dated such and such, the joint secretary, the writ petitioner informed the joint petitioner to the government of the by letter says that 3 plots are free from encumbrance and there is no borga in plot number. It is submitted that this statement as well as the statement made in annexure P1 to the writ petition is contrary to the record of rights of the said plot and shows that one such and such. So, my lords.
What is the modification that you're asking for? You have said order should be modified. That's a very vague statement. What modification are you asking for? You should be very specific on that because it has been disposed of. The contempt application is pending. What is the exact modification that you want?
Modification execution of gift.
You're actually asking for setting aside the order in its entirety.
That is not so in reply we shall deal with that what type of they have.
Please show me in the application is not entertainable.
My lord's direction was to execute the gift deed.
You have asked for modification of the order. Yes. What modification have you asked for?
Modification since petitioner's contention was the land is free for all encumbrances. So considering that point, my lord pass this order. Form record reveals
Not only the petitioner submission, it's a consent order as far as I can remember.
And my lord, after exchange of correspondence, when finally they disagreed, their writ petition was filed. Annexure P5 writ petition stated that yes, we are agreeable to conduct the deed of gift.
Consent order.
We are the praying for modification, the terms and condition he prayed for. That
stated that in your application. What modification are you praying for? I do not find it. When you ask for modification, you have to specify what kind of modification are you asking for. Only modify the order doesn't say anything. It's absolutely vague.
That's to the type.
So I'll reject it here and now, your application.
Give a liberty to file a supplementary. Difficulties is that this in view of this is not possible for to execute the gift deed. So we have ready.
It was a consent order. So this court will not hear any impossibility now.
It is likely to be consent because once annexure P5
at the time of the compliance, it is detected that these are the difficulties. That is.
Difficulties have also been dealt with in the contempt application.
This is the difficulties.
They are trying to get rid of the contempt. The application filed at related stage.
Now, kindly modify this. They can give.
How?
Now, they cannot impose. They do this for this and that way. That was in the representation. Kindly take up.
Has passed an order. This is a contempt application. You are asking for modification of the order. You have not stated how the order should be modified.
Only one chance by supplementary affidavit.
Withdraw this. Supplementary affidavit will not help because the prayers are also wrong. Please withdraw your application.
Reject the application and come forward with the contempt application.
Liberty due to that.
Liberty was earlier also granted to them. It's the eighth day of hearing. Always they took adjournment, file multifarious affidavits.
Press application for modification.
So this is no ground for modification at all. Affidavit in opposition submitted. Can you order have a can one of
this is eighth day dealing with the contempt application, and every now and then they are coming with a fresh affidavit, fresh frivolous petitions, etc.
Paragraph.
Damaging the intention of the court.
Contemptor seeks to withdraw the application being can 1 of 2024 on the ground of certain defects detected therein, and seeks further liberty to file a fresh application on the same cause of action. Paragraph such liberty is granted.
মানে
The application being Can 1 of 2024 is dismissed for non-prosecution. Paragraph, liberty is granted to the alleged contemner to file a fresh application on the same cause of action. Paragraph, there shall however be no arrest to costs. Urgent certified website copy.
my client always coming to court is senior citizen with the hope that his desires will be materialized, and he also present today also. It is the 8th or 10th occasion this matter is taken up for hearing, and always all the time he has cited frivolous site plans, new pleas, etc.
Why
In
don't you sit with the authority and come to an amicable?
My lord, we have already sat with the authority. I have
You are
stated.
ready to give the land, the authority is not in a position.
My
to
lord, see the last paragraph of my affidavit file today. My lord, come at page 6 for a moment.
Yes.
Paragraph G. I humbly, reluctantly compelled to submit that there is some hidden reasons for not materializing the gift by the state authorities, and there is undue influence of caste discrimination, as the donation of land has been intended in the name of parents of the petitioner, who is a scheduled caste, Sapka Rajbangshi, a Chandala Muchit, a government pension holder. This is the hidden reason. See, my lord, there are 10 respondents, only respondent 2 has been, or only respondent 2 has been direct to file. Other respondents from behind, from the back, they are biting and inducing joint secretary to act in this way. They are below category staffs. All the other respondents, all the inferior quality, they are directing the joint secretary. You do this, file appeal, etc. And on this such instruction, say respondent advocate are conducting this case. Already there was previous correspondence that state authority was agreeable to the proposal.
There is no question of modification. If you are really aggrieved, you can go before the appellate forum, because this court will not modify the order. It's a consent order. There is no question of modification of this order.
My lord,
I'm giving
and
you another
another,
contempt application. You have to issue rule on the next day.
my lord, what is fallen from my lord, my lord, why the petitioner is not sitting, my lord, we are ready, my lord, that the terms and condition he is
What
imposing
condition?
upon us.
It is
Well,
government land.
Terms and conditions.
No, Lord,
It is
that-
government land. Government should accept the. If they fail to fulfill, then they
do
it can.
that. And my lord, at that time, you have to do all these things. My lord, whether that is, my lord, the permissible.
What is the term and what
No,
all these things?
my lord, that is
Otherwise, my lord, the financial liability is there until unless the finance, my lord, the project is sanctioned with that time frame. My lord,
You are coming up with a very different story now, don't you think so?
no, that is, my lord,
No,
the for
fully
the
new
purpose
story.
of, my lord,
I
execution.
prima facie feel there is nothing for modification. If you want to go before the appellate forum, you can.
Next day rule will be
This is
issued.
the entire order. This is a consent order. This court will not modify. Let me be very clear and specific.
My lord,
I'm fixing a date for contempt. I'll be compelled to issue rule on the next date if it is not complied with.
my lord.
Because many dates have been spent on this. I do not want to spend further time. Let the matter appear under the contempt of court order under the same heading on 26th April. I give you sufficient time. Please be ready by the next date.
I'm grateful.
Next matter.
My lord, just 5 minutes back, I have received the compliance report. Let me go through it, my lord. Kindly fix another
You've
date.
received it today.
My lord,
You've received it today.
My lord,
Yes,
I
yes,
complied
just
the
now.
order, my lord.
Just now I have received
That is as per order.
from Mr. De, my
As
lord.
per order, my lord. Yes, sir.
He wants to go through the report and come back. Affidavit of compliance submitted on behalf of the alleged contemner is taken on record. Paragraph, learned counsel for the, on prayer of the applicant petitioners, the matter is adjourned. Paragraph, let the matter appear under the same heading on 9th April.
My lord, short date may be given, my lord. Because, my lord, as per order, my lord, as per your lordship's order, I have complied. In spite of that, my lord, my lordship wanted to see the
27th March.
yes, my
As your lordship wishes.
lord. Short date is also.
Next.
Now.
For the petitioner, it's a contempt application arising out of your lordship's order for the first
I
time.
think for the first time, please
First
stop and come back.
My lord.
The applicant petitioners are directed to serve copy of the contempt application along with annexure thereto upon the alleged contemner and file affidavit of service on the adjourned date. paragraph, let the matter appear under the same heading on 26th April.
26th April.
Yes.
I will just take hopefully 5.
Respondents,
I appear on behalf of private respondents led by Mr. Shoptangshu Bosu. He is on his legs before another court. I will request,
to complete.
let him complete, my lord. And if Mr. Basu doesn't come, kindly accommodate me for this day, my lord. Mr. Basu will go.
State Mr. Bottabel is appearing. Yes.
Well, this is, my lord, Lordship recalls, this is the ULC matter where irregularities have been pointed out by me as the next door neighbor. I have a right to get the property in case. So there was irregularity. It has been found out, as in Section 20 exemption. The property was being transferred for some other purpose. That the 20 exemption was not being complied with has been noted by the appellate authority. But my appeal has been dismissed on the ground of locus standi. And locus standi is the ground. I have challenged it on the ground that.
The ground taken by the respondents also.
Yes. That was my appeal was on my writ petition is on the ground that this was not the date fixed for hearing. The date fixed for hearing was after certain reports came.
Yes.
So then when the next day when the reports had not come, we pointed that out. So it is not ready for hearing. So my appeal.
Yes.
This is after admitting the appeal, it is dismissed on the ground of locus standi. So, Mother, I had cited the judgments on locus standi. I had, my lord, only judgments remaining to be cited since, Lordship, my principal point was that this cannot be done because it was not the date fixed. For that, I had cited several judgments, but by abundant caution, I am also covering locus standi. I had cited the judgments on 2005 3 SCC
Yes.
and 2000
Sai Chalchitra.
Yes.
Yes.
and MS Jairaj 2000 volume 7 SCC and the
Yeah,
Calcutta
yes.
High Court 2015 Calcutta. That locus standi and a writ petition, even in a non-pill case, has been diluted to an extent that so long as you have not come with any adverse intention, then in that case, you should not be denied. Just because you have no direct commercial interest should not be a factor. Like that's why I am one cinema hall owner can challenge the non-renewal of license of another cinema hall owner and ask the authorities to close them down, or like that. All those judgments are there. Now, Mala, I am putting now my next point is that this is a higher case than that. Apart from this, I have a right to acquire the property. It is because this is public land. So private property, if I have that much locus to go against even my rivals, when it comes to public property, then my right is at a different level. Anybody can go and file a petition saying that in a park in Moidan, there is a building coming up. So for that proposition, Roshi, I'm relying upon 2000. Firstly, the judgment reported in 2000 volume 2, Supreme Court cases 451. That on the proposition that Section 20 exemption is granted only when it is found there is excess land. So it's vested land which automatically vests, but you're allowed to retain. It is like Section 6.3 of the Land Reform. Allowed to retain. So so it comes with various restrictions. Or she kindly comes to paragraph 9 of this judgment.
Yes.
But the word hold in section 21A and 21B cannot, in our opinion, have the same meaning that can be attributed to it as in section 2L. The very definition of 2L states that the subsection applies unless there is anything in the context which suggests a different meaning to be given. In our view, in the context of 21A and 21B, the definition given in 20L cannot be applied. The reason is that such a construction will make section 20 unworkable and osure. We have pointed out above that it is not possible to make any meaningful application for exemption under 21A or B unless the exact quantum of excess is determined under section 10 after following the various provisions of the Act relating to statutory deductions and mode of computation. If the contention of the state referred to above is to be accepted, then the peculiar position will be as follows. As stated by us before the excess is determined, a person will not be able to seek exemption because he does not know what is the actual excess land. Hell, and once the excess land is determined, he cannot apply because he is not holding the excess land. Thus, the entire object of section 20 will be frustrated. That is why we say that the definition of the word to hold in 2L cannot be applied in the context of 21. So, for that is an exception made. Once it is determined, it doesn't automatically, you don't get dispossessed, but you get the other chance to apply for exemption. And one unreported judgment of our High Court. And issue unreported copy did. I want to go read it. Well-wisher Electronics. Paragraph 17 of this judgment. The contention of the petitioner, last page. The contention of the petitioner that the provisions of section 6 to 10 of the Act of 1976 has not been invoked for the purpose of determining excess land is not acceptable. An order of exemption under section 20 of the Act of 76 presupposes the existence of excess land. It is made on the application of the party seeking the same. Excess land has been specified in the order of exemption. The petitioner has accepted the quantification of the excess land as appearing in the order of exemption. The petitioner had persuaded the authorities on the basis of an application for exemption to grant the exemption on the condition specified in the order of exemption. While applying for exemption, the petitioner has accepted the fact that there is excess land. The petitioner has sought to take the benefit of the order of exemption. Its failure to comply with the conditions for continued exemption does not vest it with the right to contend that the quantum of excess land has not been duly determined under the provisions of the Act. Therefore, the petitioner cannot be permitted to turn around and say that the excess land has not been specified by invoking the provision of section 6. This I am citing. This I am citing for double purpose. One is to show that this is vested land in the state. So you cannot say that nobody can point a finger at. If it's a vested land, for example, if I see a jute mill, which obviously has a 6-3 conversion, being converted into a shopping mall, I have a right to come and tell the court that without the permission of the security department, a 6-3 vested land under ST acquisition that cannot be converted into a mall. And I can tell and I can approach the court and say, ask the government to take possession. So it is like this. That's my first reason. And my second reason is, now they have now realizing this fact, tried to take an about turn. Kindly see page 414 of the writ petition. Page 414. This is the penultimate order, the order by which the penultimate order it starts at page 413 where those reports were called for. Kindly come to page 414.
Yes.
Kindly come to the second paragraph, that is seventh, eighth line from top of the page. The advocate representing ISAB India Limited in reply submitted that the subject line was mistakenly come under purview of ULC Act. After having enjoined the exemption, which the exemption is that page, the exemption, now because they realize that they are not comply with the exemption conditions. Page 53 is the exemption, 53. So they now can't take the about turn and say mistakenly ULC Act. The same stand is recorded in the impugned order at page 431. 428 it starts at 431.
Yes.
At page 431. Okay. 431, Lordship kindly come to the second or third paragraph, as in the appeal. Lordship has got it. As in the appeal petition received on 18th February, the appellant countered the stand of ISAB. That IOL had mistakenly taken exemption. IOL is predecessor. Taken exemption under section 20. And as in the first hearing, the advocate concerned on behalf of ISAB claimed that they have obtained one NOC from the CEO that relaxes the provisions of excess vacant land. So mistakenly obtained, so that they cannot say. And Lordship, my last submission, page 431, Lordship, same page, the previous paragraph. Previous paragraph, Lordship kindly comes to where in response to the allegations made by the appellant that ISAB India Limited has violated the provisions of the order of 29th October, that is at the section 20 exemption, the ULC authorities in UDMA informed that since no such proposal for change of business or initiation of new projects was received from ISAB Limited, and it was reported that ISAB has stopped functioning since 2015, one notice by 268 so dated 5th April 2021 was issued by the authority concerned to the said company asking to show cause for non-compliance with the order of 29th October 92, and ISAB Limited has duly submitted the reply, which is under scrutiny of the ULC authority. Now, we don't know what happened. So we have made an application, because we have got this show cause notice earlier, that they should be called upon to explain what has happened to the show cause. After all, 5th April 21, this is a can 1 filed by us. Koi file করেছি আমরা? 12th on 13th March it was filed. Lordship has got the can 1.
No.
Can 1 আছে ওখানে?
লিস্টে আছে। Can 1 না পাইলে তো একটাই।
Can 1 24.
Have you received copies, Mr. Chatterjee?
No.
Of course.
আমি কোথা থেকে উন্নয়ন সপ্তর্ষি মাধব
It has been served on Priyabrata Watermal and on the state, but we shall give a copy to
When
Ms.
was it filed? When was it filed?
12th of March.
আমি কি মনে মানুষই না
অমানুষ হয়ে জন্মেছো কি করে বলো? উত্তম কুমারের জন্মেছো আর কি করবে বলো?
মানুষ হয়ে জন্মালাম তুমি
আমার একটা দিয়ে দাও Lordship, But you kindly come to page 16.
Of the application.
This is the show cause referred to in this order. We have been able to get it only recently.
Yes.
Page 16. In fact, this is Lordship will find even before we came to court.
Yes.
Lordship, the last two paragraphs. Now, in view of this, SAB is directed to show cause as to why this department will not take necessary action, as this department was not informed by the said company about the closure of the factory on the exempt land since 2005. Here is written 15, 2005. While the land of SAB in Mouza so-and-so was exempted in favor of IOL under 21A, with permission to transfer the same to SAB on the condition that SAB will use the land for the same industrial purpose that of Mrs. IOL. Further, an explanation also being sought from SAB as to how they have obtained the conversion certificate of the land from ADM DLRO North Park for industrial park without any permission from this department. So it is not a case where I am making a frivolous allegation. There is some substance. This was a show cause was issued as far back as in 2021 April, which came out, which saw the light of the day at in the order of 19th April. Well, I will conclude by showing that if the authorities take appropriate action, whatever action they'll take, in case the vesting should be cancelled because of this, like as was the well-wishers case, vesting was cancelled because somebody was not complying. Then in that case, I am not a stranger. I will be eligible, last in the order of priority, for getting this land. That is page 215 of a scheme of the page 215 of the UD department, Land Reforms Department, 215.
Yes.
There's a long subsisting scheme of 13 July 1982. Allotment of lands vested under the urban land ceiling. And I should see that the subject, allotment of land vested under the urban land ceiling act. Paragraph 2, 23(4) of the said act provides that disposal of excess land, vacant land, will be made by the state government to subserve the common good. Keeping in view the said provision, the government has since decided as follows: a mode of allotment. The priority in the matter of allotment of the vested excess land is mentioned below. First is government offices. Number 2, we are numbers 6 and 7. Housing for industrial workers, and 7 allotment for industries. So we would be eligible before this land goes to the private sector. So I have a locus in the vesting being cancelled, and Lordship, and this being my exact common boundary, and I have a factory there, it will be assisting me in expanding my factory. I have a running factory, and their factory is gone. That is my humble plea. I'm grateful to God.
Yes, now whose turn?
Lord, as I have stated, Mr. Basu is leading me. He is before another court, so kindly, Lord, accommodate me for another day. And Milord, there is an application.
Make the submissions after Mr. Basu.
Malad, after
After
Mr.
Mr.
Basu.
Basu.
Yes, Milord, because I need to hear what he's saying, and then I will say, Milord,
He
whatever
is
the
the answering
department.
respondent, I believe.
Yes, Milord. He is the answering respondent. I am basically, Milord, I decided the
The icing of the cake.
my lord, one indulgence, if the application has been served, my lord, so if an opportunity to file an opposition is given to us, my lord.
The application where
It's basically against me, not them. So I will, my lord, basically, I will have to use an affidavit.
Well-
Because they've made out a case of collusion, my lord, in that application.
The allegation is there also.
you don't.
But
need
I will
to
not
file
make
it.
any further.
I will also
submission.
file, my lord.
The state,
But I won't make any further than the submission.
Mr. Protocol.
do you also want to come back with an opposition? I don't think so. I don't think so. State is a silent onlooker in this matter.
The
But my
state,
submission is over.
for a change is speaking through me.
Yes?
The state, my lord, for a change is.
State is speaking through you.
No,
State,
in a way.
not Mr. Basu's client.
Main respondent is Mr. Chatterjee's client.
I hope to be pleasantly surprised with what you are
I've
saying.
nothing to do with
Yes.
Mr. Basu.
Is the authority.
Let Mr. Basu reply first.
I said, very good.
Third learned counsel for the petitioners. Paragraph on prayer of respondent, on prayer of the fourth respondent, the matter is adjourned. Paragraph, let the matter appear under the তারপর একটা line. Respondent numbers 2, 3, and 4 seek to use an affidavit in opposition to the application being Can 1 of 2024. Paragraph, let the matter appear along with the application under the same heading on 25th April. Next matter. Yes, Mr. Mondal, you are reviewing it. Report. Have you received the?
I just now received it, my lord.
So another date.
This is an exceptional report, so far as I understand, because he just my learned friend just now told me. Acquisition was done. Again, it was taken out. My land is free, but my lord, problem is why I have come up to your lordship. I'll definitely try to make something else out of the report, but then, so far as they are concerned, on my plot of land, there is a 2-storied house of the forest department. So let me take that house along with it. Let me take the possession. Kindly seize my report.
Will you come back with an exception?
I'll come back with an exception. Your lordship kindly fixes the date, so that I can come back. Yes, yes, yes.
Report in the form of affidavit submitted on behalf of the state respondents is taken on record.
You know.
Paragraph, learned counsel for the petitioners seeks to use an exception to the report. Paragraph, let the matter appear under the same heading on 29th April.
29.
Please serve an advance copy, otherwise we lose another date.
I cannot oppose him, my lord. I respect him a lot. I cannot. Otherwise, I would have shouted out. I'm grateful. I'm grateful.
Respondents, Mr. Pankaj.
There was a direction upon us to take steps for removal of the pipeline and also payment of compensation.
Yes.
I have taken instructions as far as the removal of pipeline is concerned. The entire public purpose will be disturbed. So I'll as for the and that will also not inure to any benefit of the petitioner for the timing. What he seeks really is the compensation for the land, and if not acquired, then the entire value of the land.
Say that it is not acquired.
Your submission. The problem is that we are not having the documents to establish that there has been an acquisition of this part, but the land where the pipeline is going, that is between the national highway and the relay line. So, there's in our mind, we have a presumption that there's an acquisition, but we cannot support it by any records. That is how our affidavits have also been filed. We are not claiming the acquisition. But my lord, if I may say this, my lord, what the petitioner ultimately seek is the compensation for the land, because perhaps it is not in a position to be used. So, my lord, your lordship may kindly, my lord, consider directing the district magistrate to ascertain the compensation, and also, my lord, explore the direct purchase, my lord, if the petitioners are agreeable to that.
So you agree to directly purchase the land from the
So, my lord, only with the caveat, if not already acquired. If not already acquired, my lord.
petitioner? Because on the earlier occasion, you
Yes,
admitted
Malad.
that it is not acquired.
We don't have the document. We don't have the documents to support it. Malad may record it also, that it is my submission that we are not, that my submission is that we have a presumption of acquisition, but I cannot show any document. Malad may record that submission. But Malad, in the directive portion, Malad, of the order, kindly, Malad, adds this part, if not already acquired. Kindly, Malad. Otherwise, Malad, if at all it is acquired, if the DM finds ultimately that it was acquired, then Malad, we'll have to comply with your lordship's order, again the proceeding of direct purchase has to be conducted. Only that much. That will not prejudice the petitioner. If it is not acquired, it is not acquired, madam.
Another date for the documents. I will not pass such an order which will not inure to the benefit of the petition. If acquired, one step. If not acquired, direct purchase, that cannot be done.
Very well, Malad.
Not really helpful.
But Malad, the removal of pipeline, Malad.
Pass uncertain order.
Very well, Malad. Malad, but the removal of pipeline, Malad, kindly, Malad. But we will be bound by that direction, Malad. Kindly record, at least, Malad, for the timing, record my submission. The removal is very difficult for the timing. And Malad, kindly direct us to look into the aspect of direct purchase. And we'll come back with the instructions.
In the India report, the respondents categorically stated in paragraph 3 that the aforesaid plots are adjacent to the NHS which had not been acquired. In the report submitted by respondent number 7, paragraph 3, they have admitted that, my lord.
By respondent number 8.
My lord, respondent number 7.
7.
File the report. The Bandhavata has gone through the same on the basis of that. Bandhavata prayed for that the matter may be, the land may be demanded.
I'm not denying that. I'm
also your submission, fair submission. Demarcation has been made. They've admitted that the 2 plots have been used entirely.
Yes.
So since it is not acquired in terms of the report of whose report is this?
But this is by the
Engineer.
Yes.
He relies upon a note of the special land acquisition officer. Who's the authority?
Yes.
Yes, he says it's not acquired. So why don't you go in for direct purchase?
Yes, my lord, kindly direct the respondent number 3 accordingly. That is, direct purchase will be by the DM, my lord. And he will do it through the district level DLPC, purchase committee. So, my lord, kindly direct the respondent number 3 to initiate the direct purchase process.
Do you agree to this?
As because, my lord, actually the land has already been there. Now, if
Are you agreeable to this direct purchase?
my lord,
In terms of the present market rate of the property?
Yes.
So I'll record your
Yes,
consent.
my lord. But though I have not taken instruction from my client, but the entire land which has already been damaged. It
So
cannot be used.
that is what I am submitting. Removal of the pipeline per se will not help the petitioner.
Right.
But the public purpose for which the pipeline has been laid, that will be disturbed.
It is submitted on behalf of the state. NHI has nothing to add. On behalf of the state respondents. That
Hello.
since the pipelines in the plot in question are for the benefit of the public, removal of the same shall frustrate the said purpose and shall also not inure to the benefit inure to the benefit of the petitioner in any manner. Learned counsel candidly submits that the plot may be purchased directly from the petitioner by the authority. It also appears from the report in the form of affidavit submitted by the assistant engineer, Contai subdivision that the Special Land Acquisition Officer, Purva Medinipur, has stated that the plots in question have not been acquired. Admittedly, the plot has been utilized. The petitioner is, paragraph 1, the petitioner is agreeable to the proposal for direct purchase of the plot. Paragraph in view of the above, the writ petition is disposed of, directing the third respondent, the district magistrate, the third respondent to initiate proceeding for direct purchase of the plot in question at the present market rate of the plot.
2 plots, my lord.
Plots
2
করুন।
plots are
সবগুলো plots করুন, না? Plots. And take the proceeding to its logical conclusion. I give you 4 months. It'll take some time. Within 4 months from the date of communication of this order, upon affording reasonable opportunity of hearing to all concerned, including the petitioner, comma, in accordance with law. The fund will be placed by? The fund will be placed by?
But the funds will be placed by the department, but kindly not direct to that extent. If it is
Because the DM will come on the next day and say, I'm helpless. I've done my job.
I am here for the DM also.
Yes, but that happens, isn't it? This is happening in all the cases of direct purchase.
The funds has to be placed by the relevant department, but I doubt there at all a party there. Yes,
So this order should suffice, you say?
paragraph is
but it should. Because he'll have to complete the process.
Oh, চারটি লাইন হবে। Disposed of একবার বলেছি, আর বলা দরকার নেই। There shall have been no order as to pass since no affidavit as a settled. Disposed of দুবার বলবো। Disposed of 4 months.
4 months. Your lordship matter is pending.
No, have disposed it of.
Disposal.
No use keeping it pending further. You'll be given an opportunity of hearing,
My lord.
present market rate, and 4 months.
So long Mr. Banerjee.
I hope you will not have to come back in. I hope.
So, very fair submission before lordship, but I have accepted, my lord. Thank you.
Next. Petition.
Lord, I'm for the petition.
রিপোর্টে দিয়েছিল এখানেই আছে এটা হচ্ছে আরএস রেকর্ড হবে 1496
You want to use an exception, not necessary.
No, my lord. On the last occasion, my lord, submitted before your lordship that, my lord, it can be disposed of, my lord, with the materials on record. My lord, on the last
So
occasion.
exception is required.
No, my lord. Kindly records. On the last occasion, your lord, my lord, Miss Roy, my lord, indicated that, my lord, she is, my lord, willing to
My
submit
lord,
on the
some
nature of the land.
My lord, on the last occasion, my lord, my learned friends submit that they have not been received the enhanced amount of compensation as per their terms, my lord. My lord, my submission is
received.
My lord, my submission is, my lord, as per and it is also reflected in my report also, my lord, they have received the enhanced amount of compensation in respect of the VT class of land, my lord. Yes, my lord. This is my submissions and lordship. They have been.
My lord, may I then make my submission, my lord?
Yes.
My lord, kindly takes up my writ petition, my lord. My lord, my grievance was, my lord, with regard to, my lord, the enhanced, my lord, page number 22 of my writ application, my lord. My only grievance was, my lord, that with respect to, my lord, the different classes of land, my lord, enhancement was made by the arbitrator. And, my lord, in the last line, the arbitrator, my lord, indicated that let this order be communicated to the be communicated by the competent authority NHEI and ADM to all concerned for information and compliance. My only, my lord, submission, my lord, my only grievance is that, my lord, this compliance was never made, my lord. So far as to the rate of enhancement, I have no objection.
So far, my lord, as to the compliance, my lord, what will my lord happen? My lord, now, my lord, the price of my land will also increase. This part, my lord, has not been taken care of, my lord, by the my lord concerned, my lord, after this award. And my lord kindly takes up the.
My lord, he categorically mentioned in his writ petition, my lord, that
Now,
no
my lord,
decision
kindly-
was taken
kindly-
with respect of compensation amount of commercial plots.
Now, my lord kindly, my lord, takes up the.
In paragraph 8 of his writ petition.
My lord, my lord kindly takes up the report of the state.
Your prayer is for reassessment
My
of
lord.
compensation.
My lord,
My lord, yes, reassessment of compensation.
Reassessment, then you have to go on.
my lord, he participated in the
Excellent,
arbitration.
excellent. My lord, reassessment, my lord, since my lord, the enhanced amount, I have no objection. What the arbitrator has decided, my lord, in my favor, and also, my lord, in favor of the others of the same moja by a, my lord, common order, it has been disposed of. So far as, my lord, the enhancement, I have no objection. Well, my lord, after that, it has to be reassessed in accordance of my plot. That part, that
The individual reassessment.
individual assessment.
Where is that assessment? Is it reflected?
My lord, he participated in the arbitration proceedings. He received the
On the last-
compensation without prejudice. My lord,
Where is it that he has received the
My lord,
Yes, my lord, kindly, my lord, takes up the report of the state.
in page 5 of his writ petition, my lord, he mentioned that, but no.
My lord, this was, my lord, this was kept pending, my lord. This was only kept pending because of the, my lord, this was only kept pending by your lordship, ladyship, my lord. Only because of the fact, my lord, because, my lord, my learned friend, my lord, indicated that, my lord, with regard to the class of land, my lord, she is, my lord, willing to submit on some merit.
Well, regarding my lord, he received the compensation in terms of the VT class of land as per the record of rights.
Where is the document?
My lord, as per my arbitral calculation has also been done. Page 20 of my report, kindly see, my lord. Calculation has also been done.
One by one, please.
My lord, in page 5 of his writ petition, my lord, he said
he says calculation was not done.
My lord, he said as per the decision of the commercial purpose, my lord, he received the compensation in respect of the VT class of land. And my lord, he said in his paragraph 5 of his writ petition, your petitioner states that, my lord, Mary, your petitioner states that the plot in question is a commercial plot and a petrol pump was running there. And as such, the petitioner is entitled to get compensation based on the commercial value of the said. If not, then at least the rate awarded for VT class of land, as in the government record, the said plot is recorded as VT class of land.
Yes. Now, my lord,
The compensation.
now, my lord, kindly comes to, my lord, page 14. No, VT paini ho, you need, that is the grievance. My lord, kindly, my lord, comes to page number 14.
It's VT.
Page number 14 is VT.
Yes.
My grievance was, my lord, I have been, my lord, handed over compensation, not in terms of the VT. Therefore, the arbitrator has already enhanced the rate for VT class of land. So, according to this record of.
There is the assessment of compensation after the arbitral award.
Yes.
My lord, that
is, my lord, the state is supposed to, my lord.
And my lord, this point, my lord, kindly recorded. My lord, he received the compensation. He participated in the proceedings. After 5 years, my lord, he's sitting tight over this issue, and he again come in the year in the 2020, and he asked for the reassessment. My lord.
Page 20 of my report.
Arbitral award was on
2015, my lord.
It was in 2015. Your report page?
My lord, the report, my lord, second report I have submitted, not first report, my lord.
11 January 24, the report?
Yes, my lord.
Yes, at page?
Page 20 of my report, can you see, my lord?
Yes, it's recorded as petrol pump.
Yes, my lord. His land is, classification of his land is petrol pump.
Some classification, my lord, cannot be, my lord, petrol pump. It has to be, my lord, VT. But kindly considers this aspect, my lord.
Where has the arbitrator decided about petrol pump in the award?
In case of petrol pump, no enhancement has been made by the arbitrator.
Petrol pump cannot be a classification. On the other day also I said the same thing.
I have annexed one document, kindly see.
No,
my lord,
etc.
My lord, kindly, my lord, takes up page 14.
It's the nature of user, not.
Yes, my lord, kindly takes up, my lord.
Kindly see page 5, my lord, of my report. But we have annexed one, yes, my lord. Artist record of right, my lord. But I am handing over a legible copy. This is not legible, my lord.
It's not the artist record, it's the khajna. Fine.
But this is the artist record of right, my lord. Can you see, my lord?
Page 7 is the artist
Page
record.
7.
Says BT. Your report.
Before that, 5 and 6, my lord, page. There is no page.
Lordship kindly remembers, only point, my lord, this was.
Collector, Khote number 1.
This was second page, my lord. Can you see? Jomis ready, my lord. But 1498, court number 1499, 6, my lord, last, my lord. 1496 is the
Your
plot of the
authority
petitioner.
can record anything under the sun that they feel like. You have to come under the act, isn't it? Can Jomir Sreni be petrol pump?
But that is recorded.
My lord, kindly, my lord, takes up page 14 of the writ application once.
Your own report.
But 7 of their report and my lord, 14
lord-
of my writ application.
Page 7, my lord, in my lord, Montobbo column, my lord.
Their own report.
Page 7, my lord, in Montobbo column, my lord, written as diesel pump station, my lord.
And my lord, what?
That is
My lord,
the
this-
nature of user. You have to pay compensation in terms of the classification of the land, not the nature of user.
my lord, Sreni, clearly my lord stated, Khotian number, the second column is Sreni.
Yes. So you have to pay compensation of, in
But
accordance
my
with
specific
this.
instruction is this, my lord, in case of petrol pump, no enhancement has been done by the arbitrator, my lord.
Cannot be enhanced. Petrol pump is not a classification at all. Why will he consider whether it is a petrol pump or a warehouse or things like that? It's only the nature of the classification of the land that has to be considered.
But they have my lord, received the compensation in terms of enhanced amount in classified as BT, my lord. They have stated in their petition.
Where is it stated that he has received amount in respect of BT?
Paragraph 80.
Your document says petrol pump. This has to be set aside. This is unknown
They have
to law.
stated in the paragraph 8, your petition states, paragraph 8 of the petition, arbitration, the nature of the land was considered body, BT, Dokan, such and such per acre, but no decision was taken in respect of compensation amount of commercial plots, my lord.
No, that is mentioned.
Their
well.
grievance is against the commercial plots. They have received, my lord, instead of BT class of land.
Well, on this purpose, well, this is his only prayer, well, to consider this on a commercial purpose.
If you can show me that he has received compensation for BT, he is out of court.
Yes.
Please show me one document that you have paid enhanced compensation in terms of the arbitral award for BT. Please show me one document.
My lord, kindly takes off my averments in the writ petition after that. My lord, I state that I should be given compensation in terms of commercial, my lord, use of land. If not, then at least BT.
No, my lord.
Let us forget about the commercial part. Please show me that he has been granted for BT.
Well, their prayer is for reassessment, considering the land as no other commercial, my lord.
There is an alternative prayer also.
No, my lord, they have not prayed for, my lord, payment in terms of, my lord, BT, my lord. Can you see the prayer, my lord, prayer A,
On the
written
record made in the record of rights. The recording in the record of rights is BT. So
my-
where is the compensation for BT? Please show me.
But my specific instruction
Not
is
paid.
this, my lord, since the, my lord, land is recorded in the.
Please do not repeat that petrol pump part, please. It only shows the ignorance and the fallacy of your respondents. Please show me the BT compensation. If not, it will be set aside. Calculate afresh.
My lord, my submission is to receive the compensation in terms of the VT class of land, my lord.
He has received.
This is my instructions, lordship.
Document.
My lord, the documents, it is he is the custodian of the documents, is not the competent authority.
And he
my
is
lord.
not able to show anything.
My lord,
Your oral instruction will not help.
and my lord, the specific submission is lordship, he is admitted, lordship, he received the compensation, he participated in the arbitration proceedings, and my lord, without any prejudice, my lord, he received the
Where
compensation.
is the document showing that he received the compensation?
My lord, so my lord, this is their submissions, my lord.
Dispute. He says that the BT was enhanced. He has not received that. Please show me one document that is out of court.
This will not, they are the custodian of the documents, my lord.
But they have received, my lord, under section 3G1. 3G1, my lord, color determined amount, they have received, my lord.
Protocol, why are you rewinding? Why are you going back?
No, I am
3G5 is over.
Enhanced.
3G5 is over. So after that, the enhanced amount. Three G5 comes after 3G1,
Yes,
right?
yes.
My lord, may I only place, my lord, this is my lord, kindly, my lord, forgives me, my lord, has been, my lord, taken a print in rough page, my lord. Just one paragraph, my lord, of the National Highway Guidelines. My lord, I'm relying on 10, my lord, 10, 2 and 3. My lord, the guideline, my lord, framed by the ministry, my lord, for the while disbursing, my lord, compensation. My lord, the nature of use, and my lord, the recording as my lord in the record of rights, my lord, as on that date.
Arbitrary about enhancement comment করেছি।
So this actually goes against you. You cannot claim the commercial part, you have to get the.
Yes, for BT. But I'm modifying my lord, initial, my lord, claim.
But if you lot kindly, you have to go through his entire pleadings,
No.
my lord. He is harping on the commercial plots, my lord. His entire petition plot is
My
harping
lord,
on the commercial
kindly, my lord, then text.
The court will not grant him commercial part. I would like to see that he has been granted for the BT, the classification. Your manual also says, this is your circular. This also says that if he changes nature of user,
yes, my lord,
factory, petrol pump,
Yes,
whatever,
yes.
he is not entitled to that.
Yes.
He'll be getting the compensation
nature.
in terms of the nature, classification of the
nature.
land. I'm exactly on that.
Since
He has been paid on the classification.
But I am now also handicapped to provide different documents to show that he is receiving compensation.
Since my lord
But my lord,
friend is saying that the compensation, he has received the compensation or enhanced compensation, let me take instruction whether he has received the enhanced amount or not.
Documents.
With documents.
Instructions will not help. I need the documents.
Yes, my with document, my lord.
Otherwise, I have to dispose it on the next.
But my lord, this portion, my lord, kindly also taken into account, my lord. This, my lord, he came before your lordship after 5 years, my lord. And he participated, my lord. My lord, this portion, my lord,
continuing cause of action.
my lord, my lord, these 5 years, my lord, where he is in the 5 years, my lord. He's not been in the pleadings, my lord, in his writ petition, my lord. In a very slipshod manner, lordship, he filed this writ petition subject to lordship kind consideration. Not a single amendment about his 5 years.
My lord, kindly considers, my lord, the burden was on them, my lord, to, my lord, comply with the, my lord, the order of the arbitrator. It was, my lord, shifted to them.
There is also nothing to show that the last line of the arbitral award has been
Complied with.
My lord,
Communication.
that is,
But complied, my because we have
Where is the
calculated.
where is it?
But we have calculated by page 20
Where
of
is
my
the
report.
communication of the order to the petitioner? Verbal instructions may not help in these matters. To show documents. The order was communicated to the petitioner. Where is the document?
That is not also. Yeah, communication is not there, but in the report.
And, my lord, after receiving, my lord, if there is anything is for other arbitration in this writ petition, my lord, as when the section 34 is there, my lord, he received
not challenging the award
my
at
lord,
all.
that is the lordship, that is their submission in all the matters, lordship. He challenged, it is not this.
Yes, my lord, we challenge the award in also many of the matters. We do not approach this court.
And this is the award, lordship. And if he is not challenged this award, my lord,
Be passed by the ADM dealer or whoever, the authority.
My lord.
Arbitrator is passed, part is over. He is not challenging that order at all. He says he has not been paid in terms of the order.
But my lord,
Rather, I accept the award, my lord.
My lord, he is asking for the reassessment, my lord.
Reassessment because
In terms of the award.
received. That was the assessment.
But in terms of the award.
Assessment in terms of the award, yes.
My lord.
In terms of the arbitral
my lord.
award.
Yes.
Where is the reassessment? Reassessment means enhancement.
Yes.
Where is
My
it?
lord, we will
It is not in dispute that the petitioner participated in the arbitration held under section 3G5 of the National Highways Act 1956 and arbitral award was passed on 12th October 2015 or 14th. I cannot make out.
My lord, the award.
14th October, I think. 14th October. 14th.
My lord, 14th October 2015.
Learned counsel for the petitioner submits that the order was not communicated to him by the authority by either the competent authority, NHAI or the additional district magistrate within bracket LA bracket close Nodia
Enhance না হয় তাহলে কি করব?
as directed in the award itself.
Hence,
Stop. Also, comma, the petitioner has not received the enhanced compensation in terms of the award in respect of his plot, which is VT in nature. Paragraph, though learned counsels for the respondents submit that award was that the enhanced award in terms of the arbitral award was paid to the petitioner, comma, no document has been produced by the respondents in support of their contention. Paragraph, learned counsel for the state respondents seeks to take further instructions in this regard.
Yes.
And produce relevant documents. Two issues: whether the order was communicated, the arbitral award,
Yes.
and whether the petitioner has been paid in terms of the award.
Yes.
And please don't come up with the petrol pump on the next date. Just to be VT only. Okay. Paragraph, let the matter appear under the same heading on 26th April. Should be sufficient.
My lord, only one thing, my lord, the communication of the award, no, it is not a prayer, my lord.
Yes.
Communication of the award, it is not a prayer.
Reassessment is the prayer.
My lord,
Reassessment in terms of the award.
my lord, reassessment, my lord, yes.
The term is different, but that is computation.
April.
26th April. Huh?
26
Yeah, yes, hold on.
Next.
Hello, 14 Mr. Lalit Mohan Mahato appearing on behalf of the state respondent, and I'm praying for only not today, my lord. He has
Not
missed
today,
the
not
my lord.
Lordship,
Yes,
I'm
Mr.
appearing on behalf of the petitioner. I'm being led by Mr. Shakoshan. He's appearing virtually. Your Lordship. Yes, Your Lordship. I'm being led by Mr. Sen. Mr. Sen is appearing virtually.
My lord, kindly give us 1 day accommodation, my lord. I have completely missed the brief, my lord. That's why 1 day. My lord, we are ready for hearing, man.
1 day.
1 day accommodation tomorrow.
I have to give a date in April.
My lord, tomorrow, because interim order is still there, my lord. In their favor, my lord. So, my lord, your lordship kindly hear it out tomorrow, my lord.
You are for the?
I am for the state response. I
am sorry, my lord, I am actually online, but my lord, I would be requesting your lordship for a not today because I am actually coming back to the High Court.
I'll give a date in April. This week not possible, and I'll extend the interim order for some time. Yes.
Kindly, my lord, because I'm sorry, my lord, I am actually coming back to the High Court, so it is not proper to address your lordship like this.
You cannot actually, the Supreme Court.
No, that is why I'm saying yes, my lord, that is why I don't want to
On
address your
the
lordship.
state respondents, the matter is adjourned. Paragraph, let the matter appear under the same heading on 24th April.
My lord, I am paying only 1 day accommodation, my lord.
Lordship.
Paragraph, the interim order granted.
Because earlier occasion, they took time, my lord. Probably.
30th April or until further orders. It was heard on the earlier date. 30th April or until further orders.
Because we have given everything has been completed. Reports, affidavit in opposition, everything.
It's not a hearing matter. It's at the motion.
My lord, practically it's a hearing matter because first of all, your lordship.
Next.
Your lordship given the date on 24th April.
Yes.
And interim order till the end of April.
Yes.
Great.
Yes, my lord. I am for the petitioner, my lord.
Yeah, বললাম তো। But in this matter, Mr. Mahato is the appearing.
I don't know where he is. Give your name.
My lord, I am for the petitioner, my lord. This is the affidavit service, my lord.
Who is appearing for the state?
I don't. This is the affidavit service, my lord. But my lord, I have one mistake. Unfortunately, today I detect that I have not served the private respondent. Therefore, kindly.
There is a private respondent also.
Yes, my lord. But unfortunately, I forget to serve private respondent.
Please serve and come back.
My lord, kindly give me 2 weeks time, my lord.
Since service, affidavit of service. Since service upon the private respondent is not complete, comma, let the matter stand over till 17th April.
Grateful, my lord.
Next.
My lord, I'm praying for not today because I have left my brief on my residence at chamber.
April. On prayer of the, Mr. Day is appearing? Yes. On prayer of the petitioner, the matter is adjourned. Paragraph, let the matter appear under the same heading on 24th April. Next.
Madam.
79 for the petition, my lord. This is my exception, my lord. In this matter, a land acquisition notice has been served upon the petitioner in the year, well, page 35, land acquisition notice. Construction of Mangoshai, 9495. Thereafter, I moved to read petition before the Honorable High Court at Calcutta. The copy of the order.
তুমি আছো?
My lord.
তো কবে আজকে?
At page 48. A direction has been passed and directed consider my representation. At the time of consideration, my representation order has been passed. That is, my lord.
এটা গেছ করেছিল নাকি আগে?
And 53 is the last portion. 3% Mahato. For applicant file Hajira submitted a representation applicant along with a copy of the petition. Honorable the death certificate Lakshman Kumar and Shobhan Kumar their legal year certificate, purchase deed and other supporting paper as desired in the previous hearing and not submitted. In the light of the above fact, it is clear that Lakshman Kumar and Shobhan Kumar were awarded plot number 14 and plot number 12 of Mouja, Damontur, J number 46 respectively, but they failed to receive payment of compensation. Though the applicants herein claim for compensation is legal heirs Lakshman Kumar, purchaser of the land Shobhan Kumar, but could not produce hence order dismissed. My lord, next order, my lord, I move another writ application and my lord directed to consider the representation. Page 56 start and direction was passed. On page 57, a special land acquisition officer Purulia being the third respondent is directed to reconsider the prayer of the petitioner after giving reasonable opportunity of hearing and all interested parties including petitioner in accordance with law. My lord order. Thereafter they pass an order.
না তা বলছি না আছে কিন্তু আমাদের মিসপ্লেসড হয়ে গেছে।
And long order has been passed by the special land acquisition collector. And ultimately last page 68. Last the written argument submitted by Ram Prasad Kumar, last paragraph. 68 last paragraph, my lord.
Yes.
My lord, 68 they are here. Last my lord, page 71. Page 71, last but one paragraph. The petitioner never intimated the land records office regarding the erstwhile acquisition of their land while mutating at the same. That means they are not sure whether the land actually faced acquisition or not, but surely suppressed the information they had. No cognate reason put of petitioner of coming for relief after such a long period after claiming compensation under provision of right to fair compensation Act 2013, which can only be attracted if the original acquisition had been initiated under Act 1. In written argument, their statement mentioned that acquisition process started under Act 2 stands self-indicating and found to be a compensation, but any means including citing provision of direct purchase policy of land. Later, though the searching old records, this office found that land acquisition, Magnasoy minor irrigation scheme, but they do not match either with the referred LA case number. Their notice, my lord, indicate the LA case number. But in the order sheet, the special land acquisition officer has mentioned
My lord,
that
my lord,
referred LA case number on the year.
my lord, the report filed by us and the exception, my lord, somehow misplaced from the brief. Can I take the copy from my learned friend and argue on that point or the next day? My lord, I'm sorry, my lord, because searching my clerk has missed it.
Will you give her copy of both
what-
the report and the exception?
And the exception, my lord.
Your report you have missed.
Yes, my lord, my clerk somehow missed, my lord. I'm sorry, my lord.
Will you come back on the next day? Because finish it there.
Report and the exception.
রিপোর্ট দিয়েছেন আপনারা
রিপোর্ট আর এক্সেপশন দুটোই আমি ফেলেছি এই দুটোই আমাদের কপি দাও
Let it be urgent on the stage there. Please serve a copy.
But in the meantime, then produce the record.
রিপোর্ট my lord.
Let them produce the record.
My lord,
Without record, my lord, this case cannot be resolved.
my lord, in the report, my lord, I have substantially I have annexed all the document, my lord. This LA case does not exist, my lord.
My lord, notice has been already served.
All right, my lord. As your lordship pleases. As your lordship pleases.
Notice after that, what has happened? You have to show that.
My lord, as your lordship pleases, lordship pass necessary order.
That one.
I do not know, my lord. I have to take instruction.
Exception submitted on behalf of the petitioner is taken on record. Paragraph on prayer of the respondents, the matter is adjourned. Paragraph that the matter appear under the same heading on 23rd April.
23rd?
3rd April.
Yes. Let with the one copy be hand over to.
Yes.
Deeply obliged, my lord. Now, I have to produce the record, my lord. Deeply obliged.
We can solve the issue.
Definitely, my lord. As
Yes.
My application, my lord.
My lord, I beg to appear on behalf of petitioners, my lord.
Yes. Respondent.
My lord, I am for the respondent number 1, 2, and 3, Union of India.
Very good. Mr. Pandit is your appearing. Yes.
Lord,
Yes.
may I beg to-
Yes.
My lord, my client kindly turn to the list of dates. List of dates annexed to the writ petition.
Yes, the list of dates.
My lord, your lords will kindly have a look at the list of dates. In 1973, September, my clients purchased 8 katas of land. 8 katas of land from Byrne and Company. Husband of the petitioner. The dispute is with regard to that 7 katas of land. Central government is claiming to be vested in the central government, and the state government is claiming it to be vested in them under the State Acquisition Act. My submission before lordship will be none of the claim is entertainable on the basis of the provisions of the statute. Your lordship on the last occasion directed the state government to submit a report. The state government has submitted a report on affidavit. Kindly, my lord, turn to that affidavit of the state government.
Yes.
Is a special revenue officer of the area concerned, and kindly turn to the report part annexed to this affidavit.
Yes.
That from the RS record of right, in RS Katiyan number 886, it is evident Bengal Coal Company Limited was recorded as an upper tenant, and Byrne Standard was recorded as an under tenant on the basis of possession on the date of vesting, that is 15th April 1955. What is more, it was noted in the said petition that provision section 6.3 is applicable to Dhara Procedural. It is pertinent to mention here that 6 indicates that 6.3 of the West Bengal State Acquisition.
That your lordship is reading the report on behalf of the respondent number 6.
Yes, the first page.
First.
Yes. Yes, sir. Continue, sir.
Kindly turn below. They are annexing the record of rights. State is annexing the record of rights. I think the central government has no case in this regard, not disputing the correction of the statements made by the state. Kindly turn below to page 14 of this report.
Yes.
The correct copy of the record of rights.
Yes.
Just below the middle, Dakhel Car. Has the lordship got Dakhel Car?
Yes.
Left-hand column, Barn and Company. Superior interest is Bengal Coal Company. Bengal Coal Company was the landlord. And Barn and Company was the tenant of the Bengal Coal Company. That is a statement in the report. That is the statement in the report.
Yes.
What is the status of Barn and Company? Dakhel Car. This is in the record of rights. Barn and Company is a well-known industrial concern in that area. Barn and Company, Milord, they had manufactured. Business still is going on. Now, in 1955, Barn was there under Bengal Coal Company, and Barn was recorded as a Dakhel Car. Now, there is one judgment of the Calcutta High Court. Uniformly records Dakhel Car means a non-agricultural land. Who is a non-agricultural land? Holding land as a part of one tenancy under another person is a non-agricultural. The technical term used by the settlement department in respect of recording of rights, Dakhel Car is a non-agricultural. Where do I get it? Kindly turn me, Lord, 70 Calcutta Weekly Notes. 70. Hey, Banerjee. Hey, Banerjee, you have got 70 Calcutta Weekly Notes.
Yes.
I'll hand over 70 Calcutta.
Sir, kindly mention the page, sir.
I'm done. By this is difficulty. I haven't got the weekly notes itself copy. 1079. 1079.
Yes, sir.
Yes.
Finally, turn to paragraph 16.
Yes.
To begin from the record of rights, Khatiyar number 1544 of Bardwan Town, Exhibit 6. Your Lord, we have to send me, Lord. This is the judgment of Justice Bijoy Mukherjee. His Lordship was also on the service, an experienced man coming from Lord, the trial stage. To begin from the record of rights, Khatiyar number 1544 Bardwan Time, Exhibit 6. Records tank Dhupa Pukur at plot number 622 within the terms of Bardwan municipality in the name of Sasansat in favor of Radha Nam Sasansat. A Dakhel Car is not, as a lordship. Next sentence. A Dakhel Car is not and cannot be a Rayat. Plainly, he is a non-agricultural tenant. But he was a non-agricultural tenant. Now kindly turn to the Estate Acquisition.
Very Estates Acquisition Act. Estates Acquisition Act.
That I could hand over a copy
Yes.
of the act.
That's also the best.
Lord, kindly turn to section 2I, the definitional section.
Give me a minute, please.
7 Supreme Court.
Yes.
Kindly turn to section 2I. Definition of intermediary. Aye.
Yes, yes.
Means a proprietor who is an intermediary. A proprietor, tenure holder, under tenure holder, or any other intermediary above a riot or a non-agricultural tenant. Therefore, a non-agricultural tenant is not an intermediary. An intermediary is somebody above the riot and non-agricultural tenant.
Yes.
My Lord, your Lordship need not be worried about it. It has been dealt with the Supreme Court. Supreme Court is saying non-agricultural tenancies are not affected by the State Acquisition Act because it is not included in the definition of an intermediary. Kindly turn, my Lord, to section 4.
Yes. Section 4.
Just a second, my Lord. That is order. Section 4, notification, vesting estates, and right of intermediaries. Subsection 1. The state government may, from time to time, by notification, declare that with effect on the date mentioned in the notification, all estates and the rights of intermediary in each such estate situated in a district or part of a district specified as a notification shall vest in the state free from all encumbrances. Now, a notification has been issued, no doubt. What vests the estates and the right of intermediaries in such estate. Non-agricultural tenancy is not an intermediary. Therefore, non-agricultural tenancy is not vesting. Kindly turn to section 5.
Yes. Retention, yes.
Now, my Lord, section 5 deals with effect of notification.
Yes.
Upon the due publication under section 5, on and from the date of vesting, all kindly, my Lord, leave aside A, B, C, subject to the provisions of subsection 3 of section 6. Every non-agricultural holding any land under an intermediary and until the provisions of chapter 6 are given effect to. Even effect to. Every riot holding any land under an intermediary shall hold the same directly as if the state had been the intermediary, and the same terms and conditions immediately before the date. Intermediary interest is not vesting. The non-agricultural tenancy is not vesting. Above the non-agricultural tenants are the intermediaries.
Yes.
They are removed. What happens to the non-agricultural tenants? They become tenant directly under. Effect of the notification is so far as riots and intermediate non-agricultural tenants are concerned. They are not affected by the section 4 notification. Subsequently, riots have been brought in, but not non-agricultural tenant by the State Acquisition Act. Therefore, non-agricultural tenant is not affected by the State Acquisition Act. Upon their own showing in the record of right, Burn Standard and Company was a non-agricultural tenant under the Bengal Coal Company. Bengal Coal is removed. Bengal Coal was an intermediary. Burn Standard Company, being a Tokalkar, comes to hold it under the state government. Now, my lord, kindly turn to 67 Supreme Court. Yeah, 1967 Supreme Court. 940. Yeah, 1967 Supreme Court. 967 940.
Yes.
But may I take your lordships kindly?
About yes, my lord.
Yes.
Finally, turn to paragraph 9.
Yes.
Counsel have contended that the first respondent having merely the right to receive rent, it was an intermediary within the meaning of Act 1 of 1984. Act 1 of 1954 is the Estate Acquisition Act. That under the Act, the interests of such an intermediary vested in the state on the extension of the Act, which on the no, and therefore the association had no local standard to apply for transfer. This contention also cannot be accepted. For an intermediary as defined in section 219 of the Act means a proprietor, tenure holder, and a tenure holder, or any other intermediary above a riot, or a non-legal tenant, and in relation to mines and minerals, a lessee established. It is thus obvious that the first respondent, being itself a non-legal tenant in respect of the entire land, including the land in dispute, it does not fall within the definition. Not being thus an intermediary, it is impossible to say that its interest in the land in dispute vested in the state, or that therefore it was not entitled to apply under section 24. Section 24, your lord recalls, is the preemption application on the non-legal tenancy act. Now, what say paragraph 9 says that this particular party was a non-legal tenant. His interest was not affected by the Estate Acquisition Act, which will appear from the definition of intermediary in the Estate Acquisition. What happens to the non-legal tenant? He is not affected with the Estate Acquisition. He comes to be governed by, my lord, the Land Reforms Act. Kindly come to section 3A of the Land Reforms Act.
The Land Reforms Act. Yes.
My lord, kindly turn to section 3A.
Yes, 3A.
Section 3A was subsequently introduced. European non-legal tenants. Non-legal tenants were not affected by the Estate Acquisition Act. What will happen? Now, section 3A was introduced not in the Estate Acquisition Act, but in the Land Reforms Act. Kindly have a look at section 3A. In rights of non-legal tenants and other tenants in non-legal land to vest in the state. Therefore, there is no vesting under the Estate Acquisition Act. Vesting is contemplated under section 3A of the Land Reforms. Everything, kindly look at subsection 1. All non-legal tenants and other tenants, they are vested in the state. In spite of this vesting, under subsection 1, subsection 2 begins with a non-obstante clause. Notwithstanding anything contained in subsection 1, a non-legal tenant or other tenant under the West Bengal Non-Legal Tenancy Act 1949, holding in his cash possession. I don't know whether your lordship had the pleasure to deal with the cash possession under the Estate Acquisition Act. A person could not retain any agricultural land or non-agricultural land unless he was in cash possession.
Yes.
Now, admittedly, the non-agricultural tenancies did not vest under the State Acquisition Act. There's a vesting under this act. What is the date of vesting? Can you turn, my lord? Subsection 5. This section shall take effect from 5th of September, 9th of September 1980. Therefore, in 73, Barn Standard and Company sold to my predecessor as the first item in the record of rights. The 7 cartels are sold at a time when there was no vesting. Vesting came about in 1980. And Barn, sorry, my lord. Burn Standard sold at a time when Burn Standard was non-agricultural tenant. A non-agricultural tenancy was transferable. It transferred to my predecessor in 1970. And the Burn Standard interest came to vest in 1980. Verify, kindly verify. Burn Standard interest vested in 1980. It was subject to retention. That is subsection 2 of 3A. Subsection, kindly turn to section 3A, subsection 2. 3A2, what they could retain?
Yes.
Land in cash possession. If Burn Standard was not in cash possession, there is an extinction of the interest of Burn Standard because they could not retain it. It was not a retainable property. They were not in cash possession. They have transferred to me. I think I am clear.
Yes.
It could be retained only if it is in cash possession.
Yes,
They have transferred to me. In 1922, they come in, my lord. The railway officials, they come in and claim this is the railway property. Why? Because in 1975, there was an Burn Standard Acquisition Act. My submission, excuse me. My submission is that before 1975 Acquisition Act came into, in 1973 they have disposed. Therefore, the subsequent acquisition of management of proprietary interest in Burn Standard does not entitle them to chase me, and that is the property of Burn Standard. Before that, when Burn Standard was not acquired, and Burn Standard was a non-agricultural tenant, not an agricultural interest. There was no vesting. The property was transferred to me. State is claiming that the property has vested under the State Acquisition Act. Supreme Court is pointing out that non-agricultural tenancies do not vest. And they are claiming that the property was affected by the National Burn Standard Acquisition Act. My submission is Burn Standard Acquisition Act cannot affect me because it was transferred to me
prior to that.
Prior to that. And whether or not a non-agricultural tenancy is transferable, Lord, I had the privilege of doing several cases. 2 of them have been reported. 2 by 3, Lord, reported that non-agricultural tenancy was governed by the Non-Agricultural Tenancy Act 1949. That was a tenancy transferable and not affected by any clause of the State Acquisition Act. Therefore, in 1973, when the property was transferred to me, it was transferred. It was not vesting under the State Acquisition Act. It was coming to be affected by 3A of 1955 Land Reforms Act. That is with effect from 1980. But the peculiarity of that was not retainable with central government, because the central government was not in cash possession of that property on the date of vesting. Am I clear to your lordship? In 1980, the central government, the Burn Standard was not in cash possession. Therefore, it was not retainable. And the property was sold to me. I come to become a riot under Section 4 of the Land Reforms Act. Kindly turn to Section 4 and Section 3A itself. The retained land kindly turn to Section 3A itself, that the land retained by non-legal tenant or other tenant. No.
Mr. Mukherjee, one question that is disturbing me is
Yes.
the entire matter pertains to the Estates Acquisition Act.
No. Central government is claiming it. I am not being allowed to have an interest which the central government is claiming to have vested. Central government has come to claim it. And state government is making a claim that it is vested the Estate Acquisition Act. On the definition, I can move your lordship. What I am saying, your record of right shows this as Dakhal Kari. State has filed the report. Dakhal Kari, it does not affect. Does not vest the state. Central government is claiming it is continuing to be held. And the transfer is affected by the Nationalization Act. I'm saying it's before that it has been transferred to me. Your lordship is saying whether it is required to be taken to the tribunal. Tribunal is a court of limited jurisdiction. Act itself says it doesn't vest. Your report shows it's a logical tendency. Why should I go to the tribunal? Can you appreciate that? And I show your lordship this court has entertained it. This is a jurisdictional fact. If the act is not applicable, I did not go to the tribunal. Tribunal deals with Estate Acquisition Act, Thika Tenancy Act, such other act, not with non-legal tenancy act or with other things, or the nationalization. These are to be dealt with your lordship. Not affected, not governed with the Estate Acquisition. Let them show it is affected the Estate Acquisition Act. I will go to them. I have acquired in 1973. I am holding 7 katas of land. 7 katas of land. I am well within the ceiling. The state government has filed such an affidavit saying that it is affected by Section 6(3)(a). 3 division bench judgments, Supreme Court judgment. If the land is held below the ceiling, there is no question of applying 6(3). Therefore, mainly prayer in the writ petition is the central government is opposing my prayer. Central government is claiming it to have vested under the nationalization. My submission ask the central government to resist from doing that. Ask the state government not to take into consideration the claim of the central government because we are transferred to be before that. This is, I am not claiming any relief on the Estate Acquisition. The state authorities have filed a report that it is affected by Section 3A. If it is not governed by the Estate Acquisition Act, how can it be? Kindly turn to Lord Section 6(3)(a) applies where a land is vested.
Will you please continue on some other day? I have to take up the mentioned matters from 12:30.
My lord, when it will be convenient to lordship, my lord, I will be there. Which at 5 days.
Be convenient for you, Mr.
I am, my lord, always at your lordship. I am not a busy counsel. Only not to Wednesday and Thursday. This Wednesday and Thursday, except any other day. Except this Wednesday and Thursday.
Except?
Tomorrow and day after.
Can you come back on the 11th April?
Yes, I will do that.
Extend the interim order till end of April because it's still.
Oh, there's an interim order, right?
And my lord, kindly mark this as part heard, my lord.
That's not necessary. Come back. Heard learned counsel for the petitioners. Paragraph that the matter appear.
My lord, 11th is the holiday.
Yes.
11th may be a holiday because of.
Yeah.
Oh, right. So, 15th? 15th?
My lord, 15th April, I have some difficulty. Kindly make it after, in India after 18th.
After 18th?
Yes, my lord. 15th is my sister.
19th?
My lord.
I have no difficulty.
On the same thing, on 19th April 2024, paragraph the interim order granted earlier is extended till 31st May 2024 or until further orders, whichever is earlier.
Obliged.
Interim order extended up to madam?
31st May 2020. Since it will take some time. Yes, 687.
I'm appearing on behalf of the Union of For the petitioner is a coal block cancellation case. Coal block cancellation for Durgapur Projects Limited. Your Lordship has passed not an identical matter, but a similar matter where Mr. Charan Gupta was there. A stay on this kind of an invocation of a bank guarantee and then consequent cancellation of the coal block. Now, what order copy though? My lord, I am
Yes.
a coal block was allotted after the kind of cancellation of the previous allotments by the Honorable Supreme Court in 2014-15. It was allotted to my client Durgapur Projects Limited. Previously, it was some other entity. And this was supposedly a running coal.
Are all the respondents there?
Yes, sir. Respondent no one. I am appearing.
2 and 3?
Lord.
Have you put
Yes. Well, I have sub.
One, 2, and 3. You are for 1, 2, and 3. And what about the bank?
The bank today is not really required because the money has gone out of the bank account. 18 crores has left my bank account. Now I am threatened with if I do not furnish a further bank guarantee for 18 crores or top up my existing bank guarantee, my coal block will be cancelled. But this is the position. But to put very briefly, 2015, there was a coal development agreement with my client and the coal ministry. My lord, thereafter, my lord, it took some time. I got the ultimately mine opening permission. I got in April on 4th March 2019. 4th March 2019. Now I have been penalized today. Previously, I was penalized and 35 crores taken out of my bank account because I did not meet certain parameters. Even though those parameters, after today's finding, has been rendered nugatory because 35 crores was required to be paid by me for meeting 3 initial parameters. Lordship may kindly start with this one document. Lordship kindly sees page 125. One, 125. Efficiency parameters.
Yes.
Lordship, these are the performance security parameters. So one is not relevant here. 1, 2 are not relevant. Lordship kindly comes to 3, 4, and 5. 3, 4. Yes. Failure of submission of commencement plan within the time plan. 10%. Then failure of the successful bidder to comply with the efficiency parameters under clause 10. Such percent of the performance security for each failure to comply with the efficiency parameter as specified in the Schedule E. Or should kindly comes to Schedule E, page 206. Schedule E, page,
This was amended.
oh, this is amended at page 206, Lordship. At page 206. This is the amended schedule.
Yes.
Now, these are the amended parameters which I will have to meet.
Yes.
I am today being penalized for 7. Schedule of production reaching rated capacity as per approved mining plan 20%. Now, this is what I am being penalized for. And what I was penalized for earlier is 4, 5, and 6. Sorry, 3, 4, and 6. 3, 4, and 6. 3, 4, and 6, not 5. reporting of deviations from approved mining plan, then ratification of deviations of approval of revised mining plan, and 6 is opening of escrow account. For this, I have already been penalized. While my writ petition was pending, I got an interim order, and the matter was sent to the tribunal. Tribunal was non-functioning, my interim order lapsed, and this money went out, 35 crores. Now I'm being penalized for number 7. Schedule of production reaching rated capacity, 20%. Now, Lordship, I will come to the what has been given it starts with a show cause notice. Lordship, kindly comes to a show cause notice at page 353, second volume. Second volume, page 353. That's the show cause. Page 353. This is in reference to paragraph 2. However, it has been noticed that the timeline for the following milestone in respect of Trans Damodar coal mine has not been adhered to. Reporting of deviations from approved mining plan. Ratification of deviations, opening of escrow account. These 3 I'm clubbing in one category, because I have something to say separately about this. Then 4 to 8, schedule of production for the year 2015-16, then 16-17, 17-18, 18-19, 19-20. Now, so this was the show cause. Now, I gave a reply to the show cause, explaining for each year, and more particularly, page 355, at 356, from the last bullet. After possession of the land as above, DPL got permission to reopen the mine from CCO by letter number so-and-so dated 4th March 2019. Now, then I have explained the various reasons why this could not be achieved for 2018-19. Show cause was for the prior period, that Lordship will find. Page 353, serial numbers 4, 5, 6, 7 are the earlier periods, and 1, 2, 3 are at the initial stage. Now, Lordship, is a peculiar situation. Lordship, kindly come to the order which is the decision. First is, of course, I have the preliminary point that without considering not a single line on my show cause response. Lordship, they have taken a decision which is at page 565. It starts from 563. Our coal block is dealt with at page 565 by the scrutiny committee. In the meantime, they've taken out by 35 crores. This is the tragedy. Number 2 is Trans Damodar coal mine. That is mine. Page 365. 565 Trans Damodar coal mine. Durgapur Projects Limited. Show cause notices dated so-and-so for the non-compliance with the various. I have only received so far, this is concerned, 26 February 21. Non-compliance of grant of mine opening with the milestone of grant of mine opening permission and coal production for 15-16 to 19-20 and corresponding replies. Lordship, I need not trouble my lord with this box. May I come to the decision statement, 566. Observations and recommendations, 566. It was brought to the notice of the scrutiny committee that the matter pertaining to change in timeline for mine opening permission was placed before the Secretary Coal, and he had opined that no change in timeline was agreed. The allotee furnished the minutes of the meeting of the 11th Monitoring Committee, wherein it is stated that Chief Secretary Government of West Bengal informed that the problems of financial distress and land issue has been sorted out, and permission has been given by the competent authority for 368.39 acres of land, and direction has been issued to prior allotee, West Bengal Mineral Development Corporation, to issue NOC for 282.46 acres of land and 85 land outside the area. The matter was deliberated at length, and it was felt at the view of one, comment of Chief Secretary, West Bengal, in the monitoring committee meeting regarding the reasons for delay in mine opening permission. It appears that the delay for MOP is due to delay in land acquisition and not attributable to the allottee. Chief Secretary, West Bengal onshore, mentioned that the issues are now sorted and the process of mine opening permission will be completed soon. The mine opening permission was obtained on 4th March 19, only 6 days after the monitoring committee meeting on 26 February. The scrutiny committee concludes that the allottee is not responsible for delay in mine opening permission, and therefore they cannot be penalized for delay in MOP. So now I will show my 35 crores should come back to me, which are taken out. The committee further concludes that as the allottee is not responsible for delay in mine opening permission, they cannot be penalized for missing the coal production schedule till the date of MOP. That is for the period 1516 to 1819. However, the committee is of the opinion that as MOP was available with the allottee in 1920, they should have achieved the production target in 1920. And therefore, they are responsible for missing the production target in 1920 as justifiable reason has not been given. The scrutiny committee therefore recommended for not imposing any penalty for delay in getting the mine opening permission and for missing the coal production targets for 1516 up to 1890. However, the committee recommended for imposition of penalty as per the provision of the Coal Mines Development and Production Agreement for missing the production target for 1920. So everything prior to 1920 has been condoned. Now, Lordship, see that this is the tragedy. In the meantime, 35 crores, I am not showing, page 399. As you kindly see, page 399. It starts with the 399. Paragraph 2. 395. DPL has been issued show cause notice of 2026 for the deviation from the timelines of the milestones in Schedule E and production agreement, that is efficiency parameters in respect of Trans Damodar coal mine. The recommendation scrutiny committee 15 meeting held on so and so has been deliberated by the nominated authority and the central government. It has been decided to impose penalty of an amount equal to 38% of performance security for deviation from the timelines as mentioned in the efficiency parameters for the following milestone. 1, 2, 3. This Lordship had seen 1, 2, 3 are the prior ones. Prior ones which are before the if your Lordship kindly sees this next to 353, 353, 1, 2, 3 are the earlier. Now, Lordship, 400, page 400. Then paragraph 4 straight away. Accordingly, for non-compliance with the timelines of above said 3 milestones, an amount of 35 crore 92 lakhs, that is an amount equal to 38% of the total performance security of 94 crores, constituting performance security submitted by Durgapur projects, is being appropriated. So 35 crores for failing to achieve 1, 2, and 3. If I go back to page 353, that's why I was repeating 353, 1, 2, 3 separately. 1, 2, 3, reporting of these are all at the preliminary stage. I have been condoned from 4 to 7 because there was no mining opening permission till 2019. This decision is taken now in the year 2024. In the meantime, I've already been penalized for 1, 2, 3 for reasons not attributable to me. Now, I got an injunction regarding this. Lordship kindly comes to the order. The order which was passed by my Lord's Court, page 5, 529. Lordship kindly comes to page 500 and 537. I was referred to the tribunal. 537. Second paragraph. Second paragraph. I do agree with such submission. However, this court, by taking Q, the unreported of division bench in the above cited case, grants liberty to the petitioner to approach the tribunal to get the issue decided. Respondent authority shall not act in terms of penalty imposed on the petitioner till 28th September 21 and will keep the order of penalty till the said date. But in case of failure on the part of the petitioner in approaching the tribunal, the order of penalty shall be operative, and the interim relief for a period of 5 days will lapse, and the petitioner would be obliged to comply with the order of penalty. So I was given liberty to approach the tribunal. I made it clear that this court has gone to the merits. So we had to go and get the similar order from the tribunal.
Mr. Mitra, why haven't you approached the tribunal in?
Well, here, but that is the whole point. Well, they were not alive to this fact previously, because the tribunal has been declared subsequently as not competent to decide these matters. Because Lordship, I will show this as was the fate met by DPL. After being referred to tribunal, Lordship kindly sees when they were referred to the tribunal passed the same order. কোথায়? Same order pass করেছিল tribunal আমাদের tribunal pass করলো যে এটা interim order continue করলো page 543. It 540 at 544 Lordship kindly comes to page 544. So we went, tribunal extended the interim order. 544. Then what happens? That matter is never heard. Come to 545. The matter was returnable after a certain date for extension. But the tribunal bench was not there. 545. Then again bench is not there. And so the order is not extended. And the order lapses. And my money is gone. Now, my lord, for this, that's why, my lord, when they came to me, I had the occasion to appear in a similar matter, where it was decided by the court that this tribunal is not equipped to decide these issues. 56? Kindly come to page 560. This is the decision which is subsisting this order. In another matter, tribunal had itself declared unable to hear these cases. 560 at 561. At 561. The last paragraph at 561. There was also the same cold block cancellation. 561, last paragraph. The point of alternative remedy taken by the learned Deputy Solicitor General under Section 27 of the Coal Mines is not acceptable. Since earlier orders of 18th August, 12th August passed by the same tribunal as mentioned under 27, that the tribunal is not equipped to deal with technical matters, including mediation in a small district like Godda in the state of Jharkhand. Hence, sending the petitioners to the designated tribunal under the Act would not serve any purpose. Now this was this is not annexed here. Oh, well, the 18th August 2018 order, which was referred to by Justice Bhattacharya, I have got that order. Tribunal itself said that we are not equipped to deal with these issues. And that's what DPL, the worst sufferers is Durgapur Project Limited, because last time we were referred there and there was no one to hear these cases.
So the earlier matter is still pending.
Earlier matter is pending before the tribunal. We will take steps to bring it back. That's what I said. Because when they came to me, I showed them. Because after that, several matters have been heard. Because this tribunal itself gave up. 18th August order recorded by Justice Bhattacharya. Lordship, kindly see. Hamare copy hai Lordship kindly comes to page 190 at the bottom. They have themselves admitted other matters. So, but we have only remedies before my lords. Only remedy.
So do the respondents want to come back with an affidavit?
But I just today I received the copy of the brief, but at least 10 days time to take instruction from my clients.
Can do that, but let the order in tune be stayed till then.
Yes.
For a limited period. Till you come back with instructions, right?
Yes. Instruction.
Mr. Mitra, let them come back with instructions. In the meantime, let this order be stayed for some time.
The order of 6th March and the order of the
At page 565.
566 and the consequential direction also at page 593 in furtherance of that. 563? 560 stay থাকলে হলো because penalty imposed on stay হয় that's yes. I will give আর copy দিয়ে
এটা শঙ্কর কপিটা জাস্ট
কপি চাইছি একটা আমরা দিয়ে দেবো
কপিটা রেখে দেন
This is the minutes of the meeting.
This is the decision, and on the basis of that, the order made is 593, which is the one which we have challenged here. That the money has gone up, has gone out. Now, paragraph 10 has been done already. I'll ask for refund. That's my prayer. But paragraph 11 is now looming at large. 11 is what is looming at large.
Staying this order for a limited period should suffice at this. The affidavit of service. The order. Passed by the additional secretary and nominated authority on 6th March order. 6th March order.
6th March.
On 6th March 2024 is assailed in the petition.
6 March started.
Paragraph heard learned counsel for the petitioner. Paragraph learned counsels for the respondents seek to take instructions in this matter?
2024 6 months.
No, no.
Huh?
Yes, 2024.
Since the order dated 6th March 2024 is under challenge in the writ petition, comma, the said order is required to be stayed for a limited period, comma, otherwise the writ petition shall become infructuous. Paragraph, let the matter appear under the same heading on কাগজ পড়ে গেল বলুন। 19th April, sufficient for you? to have an instructions?
Yes.
19th April.
Yes, sir.
Paragraph, the order impugned be stayed till 31st May 2024 or until further orders, comma, whichever is earlier.
Lordship also kindly stays the genesis, that is the seventh
That's the
scrutiny
minutes of
committee.
that's the minutes of
That
the
is
meeting.
the decision.
They can issue another letter.
Because they can issue another letter on the basis of that said decision. But this is my only fear. That is the decision, because this order also records this is in pursuance of the 21st. Or you will see reference to it at page 593. Or you will see at 594, paragraph 6. Paragraph 6. Paragraph 6 and 7. Paragraph 6 and 7, 594.
Yes, 594, paragraph 6.
Paragraphs 6 and 7. And paragraph 7 is the recommendation. And paragraph 8, it is therefore in view of the clauses, paragraph 2 and 3 of the above nominated authority.
565 is the
Yes,
minutes.
565,
Minutes.
the last part of this 566.
Penultimate paragraph of
The 566 is the first part, of course, I am happy with it at 566, but the last part, that is the recommended for imposition of penalty, that is the last two lines, in fact, at page 566, just above the Manoharpur
Yes.
dispute, the dip side.
কি বললাম প্রথম লাইনটা বলুন তো অ্যাসেল যে জায়গাটা বলছি না না একদম ফার্স্ট লাইন the order passed on 6 months auto pursuant to ওখানে একটু অ্যাড করুন pursuant to the resolution taken in the 21st meeting of scrutiny committee held on 7th December 2023 and 8th December 2023 is challenged. তারপরে since কি বললাম the order impugned ওখানে as well as
Page 566, the last two lines above Manoharpur. That recommendation of penalty. The recommendation of penalty in the
as well as the relevant portion of the minutes dated 7 December 2023 and 8 December 2023 inverted comma open করুন
however the committee recommended.
I'll just note I'll just quote that part. However, comma, the committee recommended for imposition of penalty as per the provision of Coal Mines Development and Production Agreement within bracket CMDPA bracket closed for missing the product target for financial year FY করুন 2019-20 inverted comma close করুন তারপরে be stayed till 31st May বলেছে
Matter will appear on
19th April 19th April
Fine. Good.
yes next
Charge.
Not I appear for the KMDA in this matter. Although the KMDA has been served, but this requires correction, I think, because my learned friend has made Kolkata Improvement Trust as a party, which is does not exist anymore. So it should be Kolkata Metropolitan Development Authority KIT wing. Necessary, yes. What a correction for anyway.
Improvement trust নেই এখন না
who is appearing for the KMC KMC is also a party that you served
Corporation there are private
and
respondents.
several private respondents
Several-
has been served your
where is the service
yes kindly
Well, in my London,
respondent number 13
13 only
it appears, my lord,
they stated KIT KMDA
no, Kolkata Improvement Trust 6, which does not exist.
so this can be deleted
Yes, instead of Kolkata Improvement Trust, my learned friend should add Kolkata Metropolitan Development Authority. Then he can mention that KITB.
4 is there respondent number 4 is KMD department
who special revenue officer deputy
No. KMDA department, this is wrong statement.
this is
KMD,
also wrong
your lordship, KMD, your lordship, hand over the possession, your lordship, kindly page your lordship.
It's absolutely wrong, absolutely.
you have to implement the KMDA isn't it
This is Urban Land Ceiling Authority and KMDA department, there is no such department even in the state. KMDA department, it's unheard of.
so please correct the cost title
Yes, lordship, correct, liberty to correct the cost.
Mr. Talukdar, please help him with the correct designation
Yes. Here, my lord, I cannot, my lord, suggest my learned friend. The KMDA department I have not heard. In ULC department, the KMDA department is there. So only
will you please suggest the correct nomenclature the correct designation
in respect of respondent number 6, my lord, address is all right.
Your lordship, page 97, your lordship. Letter of KMDA.
97 পেজে কি কাজ আছে 97 পেজে কি কাজ আছে
he has implemented this authority page 97
97
this was in 2022 so it should be there
97
yes
please add দুরকম এটা
হ্যাঁ
এটা
এই
KMDA, not department, KMDA. Custodian,
yes, lordship.
KMDA.
so this exact nomenclature is in the
But what
cost title
no what is mentioned in respect of respondent number 4, KMDA department.
Custodian of land, your lordship.
KMDA department, KMDA is not a department.
ডিপার্টমেন্ট আর না ডিপার্টমেন্টটা বাদ যাবে
KMDA cannot be a department. It's an authority.
কেএমডিএ শুধু হবে ডিপার্টমেন্ট কথাটা বাদ যাবে
Oh,
বোঝা গেল
all the private respondents are not served item bagged item received
No, your lordship, next your lordship. All are delivery, your lordship. Another your lordship, 2 evidence service, your lordship. In the last occasion, your lordship direction to me, your lordship, as per direction, your lordship, I served the notice and service has been effected, your lordship.
who is appearing for the KMC no one So what is the correction required in the cost title?
Only department, your lordships.
Yes?
Six request to be corrected by deleting Kolkata Improvement Trust to add Kolkata Metropolitan Development Authority. And regarding 4, my lord, I am not representing 4, my lord, my friend. I am representing only the respondent number 6.
4 should be represented by Mr. Bandyopadhyay in that case.
Yes, state.
The
Department
ULC
should be, my lord, deleted.
ULC department, yes.
There is no such department at all.
In fact, KMD is not
All
the
the special
custodian.
deputy
An officer is appointed, my lord knows
ঠিক
that.
পার্টিগুলো ভুল আছে ভাই সব পার্টিগুলো ভুল আছে কেন
This appointment done by
রেসপন্ডেন্ট গুলো সব
competent authority.
ভুল আছে কত কাটবে
They're already represented. Please do the necessary corrections.
Yes, lordship.
Correction
Yes.
to করে নাও না।
Yes,
কত
lordship.
কাটবে?
Regarding the correction, your lordship, the cost title, your lordships.
4 and 6.
4 and 6. It will be, কি হবে?
I'll grant you liberty. What
KMD
is the
ডিপার্টমেন্ট
matter
কাটা
about?
যাবে
এটা ট্রাস্টটা কেটে দাও
What
কেটে
is
দিয়ে
the matter about?
আর এটা কেএমডি ডিপার্টমেন্ট কি করে হবে স্পেশাল ল্যান্ড অফিসার ডেপুটি কেএমডি ডিপার্টমেন্ট
ওটা কারেকশন করে নেবে।
Yes, please place your case. What is
Yes,
the matter?
lordships. Your lordship, I am challenging the impugned order, your lordship, page number. Kindly see your lordship's order. First, you come to page, your lordships, 89, your lordships.
89.
Yes.
Yes.
Relevant portion, your lordship, page.
হিয়ারিং হয়ে গেছে ডিসিশন
The joint inspection of the pond in questions was held and the report prepared on the 27th December 2019 demonstrated that the 17,985.5 square meter of the water body was found in possession of the petitioner, but the area of interchange of the water body jointly inspected pages number 116 and 170 of the petition has not been recorded in the reported figures that the beside of the area such as such which are shown in the inspection report. There are other pages, water body which were inspected were not included in the report. The final statement was published on the basis of the joint inspection report and therefore does not indicate the figure of the water body which was there. Your lordships, as per direction of the honorable court, your lordship, they inspected the water bodies, your lordship. And
So a fresh inspection was made.
thereafter, your lordships, what happened, your lordship? Page number 104, they served the final statement.
Yes.
Total excess vacant land 19,410.65 square meter, your lordship. What is your lordship?
104.
106, your lordship.
Yes, 106.
Yes, lordship. Your lordship, come to your lordship, page 106, come to your lordship, page 98, your lordship. Page 98, your lordship.
Yes.
Your lordship, page 98 is chart of water body, your lordships. And the last portion, your lordships, your 1963 SUVRA Road and 23 GHOSH Lane, your lordship. Got it, your lordship. Bottom.
Bottom is 63 Sridhar Road.
Yes, lordships. Here is your lordships. Water body here, calculate the competent authority half share of the water body. Water body, your lordships, total 120 decimal, 4,896.25 water body, your lordship.
Yes.
Total area of water land, your lordship, water body plus A. 9,899.73, your lordship, page 40, your lordship, 112. Honorary 12, your lordship. 21 serial, your lordship.
112.
Yes, sir, 112, your lordship.
Yes,
21, your lordship, serial number.
yes.
Total area of land, your lordship, 9,899.73 square meter. But here is your lordships, page 98, after physical inquiry, they have been got, your lordship, half 4,896.25 is water body. And rest portion, your lordships, is vacant land. But final statement said the land has been included as a vested land in account of Pratibha Chandra Rai. Next, 116, page number.
This was done after the earlier order of the court.
Yes, lordship. After physical inquiry, but Pratibha Chandra Rai is the 1/6 here. There is mention, but not he is owner of 5,3.50 square meter of vacant land. Not only that, your lordship, the same this plot has been calculated in twice, your lordship. One is as a plot number, another is your lordship premises number.
Where is the name of the person?
Name of
Where do you get the name of Pratima Roy, whatever
yes,
you're saying?
lordships. Kindly come, your lordships. First page of the final statement, your lordships. Page number 105, your lordships.
Please place them in chronological manner, one after the other. Otherwise, I'm not able to
My lord,
follow.
he is not satisfied with the final assessment. He made an objection. My lord, your lordship, kindly turn to the synopsis of the case. It will be clear. Last portions, my lord, no, on last 4 lines, my lord. On 23rd, my lord, got it?
Yes, yes.
23rd October, sorry, my lord, August 2023, your petitioner made an objection against the said impugned final statement. A hearing notice was served upon the petitioner and hearing was concluded, but no order was passed by the Contempt. Let it be decided, order be passed. He is not satisfied with the final assessment. He made objection. Hearing concluded, but no order passed.
Your lordship, what happened, your lordship?
After
concerned-
giving opportunity of hearing to all the parties concerned.
At the time of hearing, your lordship, I raised the objection. They have been calculated the one
That
plot.
decision has not been taken.
Let me finish, your lordship. Plot number 11, 12, 13, and 14, your lordships, corresponding to premises numbers.
But no order has been passed.
No order has been passed. But they have not told me, your lordship, the KMC documents is required from the KMC. 11, 12, and 13, 14 to same premises 61 and 23 College Coast Lane, your lordship. They are not satisfied. I prove your.
So shall I dispose of the writ petition, directing them to dispose of with by a speaking order?
Yes, lordships.
Where is your objection?
Objection page number, your lordship.
120.
120.
120.
Your lordship,
And he
117.
has stated in the paragraph also, but hearing do not mention. In paragraph 31.
And 128 is the notice for hearing. Last annexure.
ওটা ভুল হল দেওয়া আছে।
You've given a detailed objection, I find.
Yes.
for the
Yes,
authority.
I put it in there, your lordship. But no order has been passed, your lordship.
Let them consider this upon hearing you again.
Yes, your lordship.
Yes.
Your lordship, main, your lordship, 117, page number 117. Your lordship, kindly KIT report, your lordship, the 11, plot number 11, 12, and your lordship.
That is on merit.
Same plot, your lordship, but they are not.
That will be decided by the
Place
authority.
these documents before the authority.
Documents has been placed before the authority concerned, but the authority concerned not be admitted this fact, your lordship. Kindly mention, your lordship, this plot number. This will be filed by one of the descendants of one of the brothers of Pratibha. Whereas Pratibha, one of the son is party as respondent number 13. He can also be allowed to raise the objection as well.
All of them will be allowed. All the respondents will be allowed, right?
If that be.
Affidavit of service. তার আগে শুনুন, on prayer of the petitioners, liberty is granted to correct the cause title of the writ petition
Yes, sir.
by recording the correct designation of the fourth and sixth respondents therein. Paragraph affidavit of service, তারপরে করুন।
Sir.
None appears for the
এই ডিপার্টমেন্টটা কেটে দেবো।
আমি আসল সাথে ফোনে কথা বলে নি। আমি
mute করতে বলুন।
কেটে দিই এইটা।
None appears for the Kolkata Municipal Corporation
Kolkata
and
Municipal
the
Development
private respondents except respondent number 30
Development Authority.
despite certs. Paragraph, the petitioners are aggrieved by the final statement prepared on 16th December 2022 by the competent authority upon physical verification of the ponds in question in terms of the order passed by this court on April 21, 2022 in WPA 12839 of 2021. It's pursuant to this order.
Yes, sir.
The petitioners submitted an objection for rectification of the final statement before the concerned authority, pursuant to which notice of hearing was served upon the petitioners and the petitioners were heard. Stop. No further communication has been made to the petitioners in this regard. Paragraph, learned counsel for the petitioners prays for a direction, petitioners seeks a direction upon the authority to consider and dispose of the objection upon granting further opportunity of hearing to the petitioners. Paragraph, upon consideration of the submission made on behalf of the parties, comma, this court is inclined to hold that since the objection filed by the petitioners before the concerned authority is pending, comma, the concerned authority being the who will consider?
Respondent number 3, competent authority.
Competent authority.
Being the third respondent herein, be directed to consider and dispose of the representation within 1 month?
1 month, yes. Why not next election sometime?
2 months. Within 2
I
months
don't
from
know
the
what
date of
time.
communication of this order, upon affording reasonable opportunity of hearing to all concerned, including the petitioners and the private respondents, comma, in accordance with law.
Your Lordship, may I submit
Paragraph,
one thing, Your Lordship. Kindly, this portion be handed for Your Lordship petitioner.
what handed over?
This portion, Your Lordship, be.
Let them
Second
consider. I'm not passing any order on merits. Let them consider first. Let them decide first.
Yes, Lordship.
Then the question of handing over comes, isn't it?
Your Lordship, Your Lordship, based
Again, decide who? Authority decide who?
But it may be given because we haven't yet made any objection as per section 10. The same may be allowed and a notice may be given upon the private.
I have stated you'll be heard. That means a notice has to be served. The
My share has not been, Your
private
Lordship,
respondent
listed.
number 13, and it on prayer of private respondent number 13, comma, liberty is granted to file a separate objection before the authority, which will also be considered by the authority at the time of hearing. Disposed of, which actually.
Petition disposed of. Did you?
Much. Fine.
Well, this is my application.
Well, I am appearing, my lord. I am appearing, my lord.
My lord,
I've made a, my lord. His prayer has been allowed, my lord. Practically, Mr. Chatterjee, the client prayer has been fully allowed. Lordship, kindly see the instruction, my lord. My junior is there. He has handed over.
instruction now.
What was the prayer?
Prayer is
Exemption of
tax and penalty.
tax regarding tax and penalty regarding the COVID period. We have considered all the representation and ultimately we have decided to consider
একটা copy দাও।
his client, my lord, must be appear before the taxing officer, my lord, along with this letter. The lordship kindly pass necessary order.
The penalty is waived. You are directed to pay the taxes.
My lord. And directly taxing officer, my lord.
Has to submit tax and additional tax applicable to him within next 15 days. My lord, the only thing applicable to him as calculated in their calculation sheet filed before this honorable court.
Yes.
Filed
This
before
is in terms of the court's order.
Yes, yes, filed before
Court's
this
order, calculation in terms of court's order.
Only add that thing. In the instruction, last but one line.
My lord, fix the date. My lord, fixing the date in the earlier order. My lord, lordship kindly see the period of taxation that has been exempted.
That's right. I am only saying you have already calculated the tax and additional tax, leaving aside the period which should be waived. But
where is the calculation sheet?
for calculation, they have given.
They have submitted it on the earlier occasion.
এটার মধ্যে দেখো তো।
I have supplied, my lord. I have given.
Yes, yes, Mr. Devra has supplied that calculation sheet.
One sheet shows only the penalty calculation.
Yes.
So that has been waived.
No, no, no. This is the earlier. এটা কবেকার? এটা 11/1 এটা না। Later on, what he has submitted, he has given one copy to me and another copy before your lordship's court. Where is that? My copy? No, আমার copy ওটা না। ধরো তো দিলাম। এই সমীর তোমাদের কাছে আছে ক্যালকুলেশন শিট? দেওয়া যাবে না, only one copy. আরে জজ সাহেবকে দে না, আমাকে দিতে হবে না।
Instructions submitted on 24th January 2024.
24th January?
21st of January.
24th January.
21st of January. Yes, yes. That is up to date. 31/12/2023. Yes.
So from here, the penalty will be deleted, expunged. You pay the remaining amount.
Only the principal amount.
In terms of the calculation sheet prepared on 8th January 2024.
My lord, my lord.
My lord, 8 January 24.
Where my lord categorically stated that this is the period.
8 January. The last page of the.
No. This is the sheet. 24th January. This is the last page.
Okay. Yes. 22nd January it was prepared.
Yes, 22nd January, and it has been communicated on 24th of January.
So let it be disposed of.
Yes.
My lord.
What more I want? Nothing
more.
The learned counsel for the respondents has placed a letter issued by the Additional Secretary to the Government of West Bengal, Transport Department on 28th February 2024, which records
789.
that the penalty calculated against the petitioner has been waived. The petitioner has been asked to submit tax and additional tax applicable to him within a stipulated time frame. An earlier instruction submitted on behalf of the respondents on 24th January 2024 demonstrates a table showing calculation of tax and additional tax. This is only tax, not additional tax.
Additional tax also?
Both
In the
Tax and additional tax.
tax and additional.
are payable by the petitioner. Paragraph, in view of the above, this court is inclined to hold that nothing further remains to be adjudicated in the writ petition. Stop, the writ petition being WPA such and such is accordingly disposed of. The petitioner is directed to pay tax and additional tax in terms of the calculation made by the authority on 22nd January 2024 as annexed to the instructions dated 24th January 2024. Within
Only I am praying, they have given for 15 days. My client only want difficulty because he has given his daughter's marriage on the last week.
So within 1 month.
Within 1 month.
Within 1 month from date.
Before the taxing officer, my lord.
Within 1 month from
Before
date.
before the taxing officer, Public Works Department.
Kolkata.
Taxing officer, respondent number?
What are they getting?
5, I think. So.
Taxing officer, man.
Five.
So no 5.
For the taxing officer, comma, public vehicles department, comma, being the 5th respondent hearing.
Yes, that's no 5.
There shall have been no arrest to cause since no affidavit or this
Deeply obliged, my lord.
Deeply obliged.
Mr. Chatterjee's gain.
This is the result of my tenacity.
By due to intervention of my lords. Otherwise not. Mr. Chatterjee not
And
getting.
your lordship's
It
constant
goes to
effort.
my lord.
Constant
This
effort.
was to be done.
Yes, yes. I am very grateful for your lordship's constant effort.
Yes.
Some has to be done. Isn't it?
Yes. Constant effort.
Next.
Deeply obliged.
Here I am for the railway, South Eastern Railway.
Petitioner, Mr. Roy?
No, এবার দেবো।
For the writ petitioner in this. Because you will remember this is a matter lordship on previous occasion. They are serving me the report today, my lord. Long back it was directed, my lord.
Possibly he was not available.
I was available. Every time I am available.
The railway authorities were not available on the earlier occasion.
Yes.
No, my lord.
I think my supplementary affidavit.
Who is appearing for the state?
No, I am here.
Mr. Same is appearing. You want to come back with it? Oh, this is a supplementary affidavit.
I can say one report already filed with respect of inspection on a particular day.
Mr. Roy, do you want to use an
Yes, my lord, definitely. Because I was not aware of, and probably, my lord.
My lord, the sheet in motion railway bridge, that is annexure R3.
Since you have served the copy today itself, he has to come back with an exemption.
Huh?
Yes, absolutely.
এটা হচ্ছে স্পিড সেদিনকে কি ছিল কম্পিউটারাইজড
It has to be countersigned. There is no sign on my representative. That was what is the policy says.
Page?
It is not paginated, my lord. Annexure R3.
R?
R3.
Yes, R3.
Any payment report, my lord, has to be countersigned. This is what the policy says and the agreement says.
As usual, no counter signature.
It is not required.
It is required under the policy. My lord has referred this in the judgment.
I'll hear it out. Come back with your.
I will be relying upon your lordship's order on the similar.
Come back with your exception. I'll hear it.
Yes, yes.
Supplementary affidavit submitted on behalf of respondent numbers 1, 2, 4, and 7. Act থেকে যাবে, TO2. It's taken on record. Paragraph, learned counsel for the petitioner seeks to use an exception to the
Only thing that for the railway sponsor, just we want to go through the same, to a copy B also.
Yes, yes, please serve a copy.
আমাদের কমিটি কোথায়?
You are entitled to a copy.
Phone with tower.
Exception to the affidavit.
বলে দেবো।
A paragraph let the matter appear under the same heading on
এইটা wait,
23rd April.
23rd April.
Interim order, my lord, may be extended.
The interim order granted earlier is extended till 30th April or until further orders, whichever is.
30th April.
Yes, my lord, definitely. I need to see this.
Should have served earlier, sir.
Yes. And previous occasion, my learned friend was not there.
ব্যাস আমার নামটা বাদ চলে যাবে, আমার টাকাটা মানবে।
Next matter.
এই 4th April কমপ্লিট হচ্ছে।
Please serve an advance copy, Mr. In the
Oh,
earlier.
yes, yes, definitely. This matter also, my lord.
I am extremely sorry because I am
Perhaps
ready to file my
express
affidavit
lordship
while
displeasure.
I can go to the one. Well, because of staff who is going to affidavit, his mother very seriously, he could not sign this document, I could not.
Similar plea was raised on.
No,
four
no.
occasions.
This is the first occasion,
No, no, it's not a first occasion.
This
my
is
lord.
genuine.
Which you cannot resist.
I cannot resist.
Yes, in this.
My lord, but the fact remains is this. My lord, this order was passed long back, 6 months back. They need to at least file some
I can
documents.
give 2 weeks time, in the event I affirm this affidavit.
And also, my lord, this is the matter where lordship, I will be relying upon a similar order passed by lordship on the previous occasion, and I satisfy all the tests. Whatever the lordship conditions have been said here, my lord, I have satisfying all the tests. So I'm entitled to refund.
Mr. Chakraborty knows that. That's why the delay.
Mr. Monol also here.
You must understand that the more delay you make, the more your case loses importance.
No, that is not.
The authority has only one ground, delay. So let them come back.
And advance copy the other. Lordship, let them at least an unaffirmed advance copy may be given.
Yes,
So
that can
unaffirmed
be,
advance copy.
that can be given here
No,
and
no,
now.
আমি তৈরি করে নেবো আমার test.
If it is
No, no.
there at all.
আছে extra copy.
One copy.
Kindly see, my lord. I could have at least within 2-3 days I would have prepared the exception.
Yes.
Copy in course of this day.
Yes, I will, This
course of
this
this-
week. Today not possible, tomorrow,
You need to have photocopy. That's all you
Yes,
have
yes.
to be ready.
Yes, yes. Yes,
Very well, by tomorrow.
Yes.
by tomorrow. দিয়ে দেবো তো।
Mr. Roy, please let me know if it is not given to you by tomorrow.
Yes, Steph. But I will not, my lord. He will do it.
There are some suppression of fact also, that I will.
That is why I have a right to deal.
A very long time.
Yes.
Give all your documents.
Yes, I will, Next day, sure,
On prayer of the railway authorities, the matter is adjourned.
Next day.
Paragraph, let the matter appear under the same heading on 22nd April.
Grateful.
No, I'm on the petition. I'm paying for adjournment.
Yes,
I'm paying for adjournment.
who is appearing for the respondents?
I'm appearing, my lord.
The petitioner is asking for an adjournment.
794, my lord. 792.
792. On prayer of the
Exception was not
petitioner.
ready, madam.
Yes.
Exception is not ready yet.
On prayer of the petitioners, the matter is adjourned. Paragraph, let the matter appear under the same heading on 23rd April.
It is my application.
I'm waiting for the
On
status.
the last occasion, a report has
Appearing for the respondents, your appeal.
a report has been submitted, but on the report there is a card number is wrongly incorporated, and I filed an exception, and there is an indication regarding my
In affidavit filed by my learned friend, he has taken only 2 points that the audio and AC is not fitted in his vehicle, Your Lordship.
because there is another card But if your
and he has
lordship,
not taken this point that the card is having another number, your lordship.
but I
It appears from-
subsequently I find out that this is the card which has been incorporated in the exception. This is the wrong card number. This is not my card. On the basis of
I'm
that, your
handing over
lordship
the
on the last
report.
occasion
I'm handing the
directed.
report which I received from the
You have filed a report on the earlier occasion.
lordship. This is
This is a second
it
report.
appears, your lordship, that the vehicle having the AC and audio both from the record.
You have challenged the imposition of additional tax.
Additional tax.
Additional and special tax.
The authority says that you have not paid the amount. This is
Authority
taken-
said that not the but.
He is taking the ground that the AC and audio is not fitted in their car, in his car.
Your lordship, on the last
Challenge
occasion,
from the record, it is fitted there.
on the last occasion,
If there is no AC and AC and audio, he has to apply it. He has to apply for that.
Let him place his case. He is the petitioner. Let
on
him
the
place his
yes, on the last occasion, I submitted one server copy. That is a WB 15C4813,
Yes.
and in the exception, if your lordship kindly find out the card number, registration number 154813, WB 154813. The two different cards.
No, lordship.
Oh, there is one C in between.
Yes, C is incorporated in my card. On the last occasion, your lordship directed my learned friend to take instruction regarding this dispute.
That point he has not taken in his affidavit also, lordship. Kindly, lordship, have
Number of the card in the exception is the wrong card number.
No, that is the same car.
So you say that if the dues are paid by 31st March, penalty will not be less.
Yes.
It will be waived.
The huge penalty.
Now, wait, let us see the writ petition, the number of the car.
Yes. Vehicle number WB 15C4813.
Yes, you are the owner of this vehicle.
This is my card.
Yes.
And in the exception, if your lordship kindly come to the registration number WB 154813.
He distributing regarding insert one.
Because
alphabet
I
C, your lordship.
never
Alphabet C, your lordship.
I never
Number is the same. Number is the same.
Never use the AC facility, audio facility, and if your lordship kindly, if the card will become.
So this amount which is under challenge is for user of AC and audio facility.
Yes.
Lordship.
Impose the heavy charge on the. This is
And he has paid till 2017. Thereafter, he has not paying.
This is stated in your report, earlier report.
Lordship. No, first report, today's, I have entered over, lordship.
48,660
That
is
you
the import.
liable to pay by owner.
Today's report shows the same vehicle number.
Lordship.
Your vehicle number, today's report.
Well, today's report has not been served upon me.
Please have a copy to him.
The second page, can you lordship see?
What does the earlier report say? So it is the same vehicle in the earlier report also.
But my lord, earlier report that the card number,
In the affidavit, lordship, he has not taken this point. He says,
I subsequent find out that this is not my card.
he says that the AC and audio is not fitted.
Kindly see my server.
Earlier report is WB15C 4813. The report is also in respect of the same number.
WB15C4813 is my card.
Yes.
In exception, they
What is there is no exception. What is the exception? What are you referring to as exception?
no, the report submitted by my learned friend, this is a registered number WB154813.
15C 4813 in the report, earlier report.
No, kindly details of the vehicles are follows. Registered number WB154813. Because I am not able and AC facility and audio facility in my car. This is a taxi flying on the road.
This should be a typographical mistake
Lordship.
because a vehicle number cannot be like this. There has to be an alphabet in between.
Lordship.
A, B, C, A, B, B, C, anything, something.
Whatever is maybe, maybe
This is your vehicle.
may,
You cannot take
very well.
advantage of a typographical mistake.
This is if this is the my vehicle, but the AC facility and audio facility is not available in the car.
Till
The
2017,
authority deliberately imposing in the extra tax upon me.
till 2017, my learned friends have paid the audio and AC.
Oh, what if I on that relevant point of time, what will be done? That is not a question. Question is the 48,000 has more than 48,000 and imposed as the extra tax in this year.
And there is also a provision, your lordship, under the MVI Act and rules.
Payment till 2617 in your report.
For conversation, he has to apply before the motor vehicle authority for the conversation of AC and audio if he has not. But there, on our record, it is there.
Where is that? It is there. Where is
In a report, I have mentioned it. It is pertinent to mention that there is a provision MV Act and rules for conversation of vehicles to be applied in proper manner, along with prescribed form and requisite fees. But the petitioner, come owner of the vehicle, did not apply for the same till date. Following this, is liable to pay the dues as per MV Acts, motor vehicles and rules.
Why will he pay the dues?
No. At present, your lordship record shows that both the AC and audio is fitted there.
Where is that record? Please show me.
Kindly lordship see the second page of my today's report.
Today's report, yes.
Lordship. Second column.
Second page.
Second page, second column. Motor meter model and website. AC fitted. Why? Yes. 1, 2, 3.
Yes, AC fitted one.
AC fitted,
Yes,
lordship.
why?
Thereafter, third column, your lordship. After 4 or 5, audio fitted. Why? Yes.
Where is
Third
that?
column. Third
yes,
column.
Yes.
Yes. Audio fitted. Yes.
And where is the vehicle number?
Top registration number WP15C4813 on the top.
WB15C4813.
Lord by Lord.
This is from the Vahan portal.
Lordship.
This is from the Vahan portal.
Lord in Lordship. This is a screenshot, and this is authorized by authenticated by the regional transport officer.
কোথায় তোমরা তো সিগনেচার করে দিয়েছো একটু যথেষ্ট
Yes, so you have no case.
No, my lord, I am not having the my lord, AC and audio facility. This is the wrong, my lord.
Challenge this. Have you
Yes, yes, I will certainly challenge this.
before the appropriate authority.
But appropriate authority.
Challenge Vahan portal before this court. Can you?
My lord, that
This
those
is uploaded by the department.
whatever is maybe, my lord, my ask myself that I did not avail the AC facility and the my lord, audio facility in my car.
Only your oral submission will not help you, sir.
But
The document says that you're availing both the facilities in your.
but I document, my lord,
This document has not been challenged anywhere before any authority. So we have to rely on this document, and you are liable to pay the taxes.
my lord, in the report which has been submitted to my learned friend in the earlier occasion, I subsequently find out that the card number is the wrong card.
It is not the
Because I am now if your lordship find out that this is a typographical mistake, that is another question. But my
You know, you are aware. Can a card number be like this without an alphabet in between? Is there any registration with such a number? Cannot be. It is merely a typographical mistake.
Shut it.
The C has been omitted to be printed. That's all.
Those facility we have not been available, that on the basis of the papers and documents, I will be penalty.
That is the law. We have to depend on the papers, the document. They don't lie.
If your lordship kindly allow me to challenge this report, which today is the file my learned friend, but kindly give an opportunity to.
Let him come back with an exception to this.
Yes, yes, yes.
Because prima
Lots to
facie
be
I did not
filed,
find any.
lots to be filed before the concerned authority about it.
No. Today you have handed over a report.
Lots.
He wants to come back with an exception to this. A further report submitted.
Your lordship may dispose it with the direction upon the regional authority to concern his representation.
Where is his representation? He has no representation before the authority.
There is no scope any representation because I challenging the.
Let's come back with the
Yes.
further report submitted on behalf of the respondents is taken on the respondents today is taken on record. Paragraph, learned counsel for the petitioner seeks to use an exception to the report. Paragraph, let the matter appear under the same heading on 19th April.
19th April. Grateful.
19th.
I give it a
My lord, 794, my lord, for the petitioner, my senior Mr. Shobhusachi Chatterjee, my lord, he is contesting in Lok Sabha election, my lord.
So,
My lord, I am praying for 1 month time kindly.
after elections, I'll give you a date.
No.
Please do not make these submissions before a court, madam, please. On prayer of the petitioner, the matter is adjourned. Paragraph, let the matter appear under the same heading on 29th April.
Although in this matter, Mr. Varun Samant is appearing on behalf of the private respondent. Although now he is engaged on another, he requested me to pray for today for adjournment, only for today.
This matter is required to take some time. It can be placed in the hearing matter because exception has also been filed. I have some.
Motion stage, affidavits were not called. On prayer of the private respondents, the matter is adjourned. But an accommodation is sought on behalf of the private respondents. Paragraph, let the matter appear under the same heading on 23rd April. Private respondents wanted to use an exception. That is also not there.
They have handed over me the copy.
Not filed.
Get close.
Next.
Lord, I have a petition.
So free is everyone's better.
Milord, I will service.
Service on the private respondent?
Yes, Milord, that is neglected. I made a, annex P3, page 20, Milord.
Respondents are not there today. Respondents are asking for accommodation.
Only consideration order.
Dispose of the
Disposal? Is the private respondent should allow?
Page 20, Milord, my.
Give me a minute, please.
12A, 12A.
6, item number 6.
Where is the service of the private respondent?
Yes, my lord, 12A, my lord. Yes, item number 6.
Detail number 6, 12A, page 12A, Milord. Yes, Milord. And after service of this matter, copy that concerned assistant engineer has served a notice to the concerned block land and land repose officer for demarcation of
This
the
is
land.
the group one matter.
Group 1 matter.
Group one matter. Let it appear.
Highway, Milord, state highways.
Consider that matter.
State highways, Milord.
Consider. You can't judge, ma'am. Only consider, my lord. They wanted only consider to.
Yes,
That-
yes.
My lord, your lordship can dispose of this matter. Otherwise, my lord, again, some time will be come.
Demarcation notice is also issued.
Yes, ma'am.
Yes, Milord.
So complete the proceeding within certain time.
Affidavit of service. Paragraph none appears for the private respondent despite service. Paragraph the petitioners claim to be the recorded owners of the plot in question and submit that the private respondent has raised unauthorized construction by encroaching upon a portion of PWD land adjoining their plot, thereby obstructing their egress and ingress. Stop. Pursuant to a representation submitted by the petitioners, petitioners on 19th October 2023, the assistant engineer, highway.
Respond number 3, Milord.
Bhatar Highway Subdivision, BHATR, being the third respondent herein, issued, wrote to the Block Land and Land Reforms Officer, Bhatar Block. He is not a party?
Yes, yes.
The petition? On 15th February 2024, requesting demarcation of the plot in dispute in order to ascertain encroachment, if any, thereon. Encroachment, if any, thereon. Please implement the PLLR also. Paragraph. Upon consideration of the submission of the parties, this court is inclined to hold that since.
Respondent number 3.
Yes. Since the third respondent has requested the Block Land and Land Reforms Officer to demarcate the plot in dispute, the Block Land and Land Reforms Officer, being the, please add him as the 8th respondent, being the 8th respondent here in be directed to hold such demarcation in presence of both the parties and submit a report to that report in this regard before the third respondent within 1 month from date. Stop. Upon receipt of such report, in the event encroachment upon PWD land or any portion thereof is found, the third respondent is directed to initiate proceeding under Section 10 of the West Bengal Highways Act, 1964, and take the proceeding to its logical conclusion within 2 months from the date of receipt of the report, upon affording reasonable opportunity of hearing to all the interested persons, including the petitioners and the private respondent, in accordance with law. Disposed of which on prayer of the petitioners, liberty is granted to implead the Block Land and Land Reforms Officer, Bhatar Block, Purva Bardhaman, as respondent number 8 in the writ petition. paragraph, the cause title of the writ petition be amended accordingly. To the necessary amendments. Next,
My lord, 797, Mr. Satik Bhattacharya is on behalf of the petitioner. He will join virtually.
appearing.
He will join virtually.
Yes,
797.
May I audible, my lord?
you are.
May I pray? In the earlier occasion, the respondent number 3, that is STA Jharkhand.
Where is the third respondent? Passover is not possible.
Yes,
Hope you're aware. The next board meeting was supposed to be held on 9th March.
But thereafter it has been deferred. Thereafter it has been deferred on 16th. Thereafter it again has been deferred. Answer, sine die. 16th malad deferred, and on 16th malad again the matter has been deferred. Board meeting was deferred, sine die.
In that case, let it be only not today. Let learned counsel come tomorrow.
As your lordship.
If she is not there, let her come tomorrow. Let her explain.
As
And
your
make
lordship.
it not today only, right? Please ask her to be present tomorrow.
Obliged,
Ma'am.
Next. Not today.
Lordship, I am appearing on behalf of the petitioner.
I am appearing for the private respondent.
State.
I am appearing for this.
Lordship, in this.
Yes.
Lordship, in this matter, the Chaudhary Travels purchased a vehicle being WB number 25J0368 by way of a loan from the IDFC Bank. The said Chaudhary Travels paid the loan by way of a monthly installment. Thereafter, the failed to pay the loan amount. Thereafter, the IDFC Bank proceedings initiate the state Chaudhary Travels. Thereafter, arbitration proceedings were initiated by the IDFC Bank, and on that day, the Chaudhary Travels never appeared before the authority. And lordship, kindly come to page 29, annexed P2, the order of the arbitrator. Lordship, kindly come to page.
Who is this Chaudhary Travels? The petitioner? No.
No, lordship.
The private respondent.
He is the auction purchaser. Petitioner is the auction purchaser.
On the basis of the arbitration proceedings, kindly come to page 30.
30. Yes.
Lordship, claimant 1, claimant will be at liberty to sell the said asset as is, whereas the basis of either by the way of lordship public. On the basis of the said, an auction was proceeded by the IDFC Bank. I appeared in the auction and I am the
highest bidder.
Thereafter, the IDFC Bank, kindly come page 34, give the NOC before the RTO Barashat. No objection for transfer of ownership with cancellation of hypothecation of IDFC Bank. First track, decision now customer wish to transfer ownership of the vehicle to whomsoever it may be concerned with cancellation of IDFC Bank Limited hypothecation. Lordship, thereafter, my client made a representation before the Tomlu RTO for registering his vehicle. But the authority did not take any step. Thereafter, my client filed a writ petition, and kindly come page 38. Your lordship's order. Transfer registration. This is your lordship order. Being the highest bidder in the auction floated by the IDFC Bank, being Being fifth respondent hearing, the petitioner purchased the vehicle in question from the bank on 20th September 2022, following permission granted to the bank by the learned arbitrator to sell the vehicle on as is various basis. The petitioner submitted representation before the authority on 8th May 2023 and 21st August 2023 respectively, seeking transfer of the vehicle in his name. The representation are yet to be considered. The petitioner pray for a direction upon the authority to consider the representation. At the earliest, learned counsel for the state respondent submitted that the third respondent be directed to consider the representation in accordance with law. In view of the above, the writ petitioner is disposed of directing the third respondent to consider and dispose of the representation submitted by the petitioner within 2 months from the communication of this order, upon affording reasonable opportunity of hearing to all the stakeholders, including the petitioner, in accordance with law. After this order, your lord, a hearing was taken by the authority. Lordship, kindly come to page 44. 44, and the order is, Lordship, kindly come to 45 page. Last portion.
Yes.
The represented, and on that date, the authority directed the said Chaudhary Travels to appear before the authority. He was not the party of the writ petition, and he is not the stakeholder because I purchased the vehicle. And thereafter, the authority, the representation on behalf of the Chaudhary Travels submitted request to adjourn the hearing. On behalf of the petitioner, submitted has been given for transfer of the vehicle in his favor. It is said that the vehicle has been taken possession by the financer owing to the default on the registration owner of the vehicle. The manager, IDFC Bank Limited, was absent for the purpose of hearing. On scrutiny of the submitted application of the transfer of ownership, it is found that the special provision regarding motor vehicles subject to hire purchaser agreement as laid down in section 51(5) of Motor Vehicles Act 1988 has not been observed by the financer. On considering the above facts and observation, the understanding directed the manager, IDFC Bank Limited, to appear before the registering authority of the vehicle bearing number such and such registered Barashat to observe the provision of section 51 as registering authority Barashat 24 Parganas in the registering authority in respect of the vehicle in accordance with law. Lordship, kindly come to the section 51(5).
Yes.
Lordship, 51(5). Where the person whose name has been specified in the certificate of registration as the person with whom the registered owner has entered into the said agreement satisfy the registering authority that he has taken possession of the vehicle. Lordship, in this case, I purchased the vehicle.
A notice is required to be served upon the registered owner. Under 51(5).
No, Lordship. Here no notice was served.
It was required to be served
No,
by the
Lordship.
financer. Please read the section.
Lordship, where the person whose name has been specified in the certificate of registration as the person with whom the registered owner has entered into the said agreement.
That is the
This is
financer.
not a
That is the
financer.
Yes.
And I purchased a vehicle from a.
You are not in the picture at all in this section.
He's a third person.
I
Yes,
am
it is
purchased the
registered
vehicle
owner.
from an auction. That's why, Lord.
Maybe,
I am purchased the vehicle from an auction process.
Maybe, but
And purchase a vehicle from an auction, and the bank give no objection NOC before the Barashat. Thereafter, as per I made a representation, kindly come, now kindly come, enter into the agreement, satisfy the registration authority that he has taken possession of the vehicle, owing the default of the registered owner under the provision of the said agreement. and the registered owner refused to deliver the certificate of registration or has absconded, such authority may, after giving the registered owner an opportunity to make such representation as he may wish to make, and not only that, the certificate of registration is not proceeded before it. Cancel the certificate and issue a fresh certificate of the registration in the name of the person with whom the registered owner has entered into the said agreement. Lordship, I am suffering because I purchased the vehicle.
Again, I repeat, madam, you are no one here.
But I purchased the
What does
vehicle.
the provision say?
Lordship, but I purchased the vehicle.
No dispute. Before the name is it is registered in your name.
Yes.
The financer, let the financer respond to this.
Yes, financer name must be there.
He has to serve a notice to the registered owner, allow him to submit a representation, if any, and then transfer the name.
Lordship directed that. Otherwise,
is
I am
the financer.
suffering. I purchased the vehicle.
Yes, yes.
Lord, there is no hesitation that we have to comply with this particular
Yes,
provision.
yes.
One of the difficulties today, what I've been instructed is, this particular vehicle, my lord, is in possession of a receiver. Because we initiated an arbitration proceeding, which was contested by the borrower, which is Chaudhary Travel. And upon an application preferred by me, the receiver was appointed, and further applications were also preferred by me, under which the tribunal gave a direction to sell this vehicle. So all these documents, my lord, are in the possession of the receiver, which is, my lord, where the difficulty has been, my lord, on our part to, my lord, comply with this particular provision.
The receiver was appointed by the tribunal.
By the tribunal.
Must be for a limited period of time. Where is the order of the tribunal?
But we kindly take
It cannot be in perpetuity, is it?
Page 29 of the writ petition.
Planet third.
Lord, we kindly takes the third paragraph. And at page 30, my lord, is the direction upon the learned receiver.
Here you were permitted to sell in on an as is where is basis. So where is the appointment of receiver? So it appears to be in your possession.
But there was an order, my lord, under section 17, which is perhaps not annexed with this writ petition. My lord, it's not annexed with this writ petition, under which, my lord, a receiver was appointed, and the receiver was supposed to, my lord, conduct this auction and sell it. If your lordship permits me, I can also file an affidavit to this effect. Lord, bringing on record, my lord, all these orders that was passed from time to time by the arbitrator.
Let him come back. Please do that. Let him come back with the report.
Lordship, I do not know whether there is any receiver after this or
I do not find any reference to a receiver in this order.
Yes, Lordship. There is no receiver. After
And why will be a receiver appointed when the tribunal is direct sale of the vehicle?
Lordship, after this arbitration,
The tribunal cannot blow hot and cold at the same breath. Tribunal asks you to sell the vehicle so that it doesn't face further deterioration.
Lordship, after this
At the
arbitration,
same time, how can the tribunal ask for appointment of a receiver? Cannot.
after this order, auction was
Purchase the vehicle.
yes, I purchased.
No, your point is fine, but 51(5) has to be complied with. A notice has to be issued upon the registered owner.
Under section 17, my lord, the arbitral tribunal has the power to appoint.
There is the order.
But that is what I have to produce by way of an affidavit.
Come back with a report in the form of an affidavit, please. Affidavit of service. The grievance of the petitioner is that though the petitioner has purchased the vehicle in question, as the highest bidder in the auction floated by the IDFC Bank Limited, being the fifth respondent hearing, the concerned authority has not registered the vehicle in his name. Paragraph, learned counsel for the fifth respondent seeks to submit a report in the form of affidavit in this matter. Paragraph, let the matter appear under the same heading on 17th April.
My lord.
Please serve an advance copy.
Lordship, advance copy.
That is exactly what I said. I have just said so.
Report filed by the private respondent.
I'm suffering
yes.
to purchase the vehicle long back. I purchased the.
Also want to come back with a report to them, right?
That is not required, my lord. In this case, that is not required. This is clearly says that 51.5 is a lordship was holding that. Yeah, now presently writ petition has nobody. Practically, he is nobody and go before the arbiter. His remedy is remedy before this. His remedy before the civil court, setting aside the arbitral award. That is receiver. No. This appointing the receiver regarding why receiver in
the arbitration procedure.
We do not know whether a receiver has been appointed.
I do not know. We do not. I also know. I not record in this.
Come back with your report.
My lord.
Please annex relevant documents. Next.
Next two matters same, lordship. Next two
Same,
matters.
same.
99, my lord, I am happy first.
Same matter.
for the state law.
Same matter. I am
Same matter, my lord.
Same. Lordship,
Report.
just vehicle number is different. Otherwise,
Let not use the vehicle number. Same order. I'm not.
My returnable or not? Returnable date, my lord.
The same date. 17th April, I said.
17th April.
Much obliged.
Lordship, I am also, yes, Lordship, I am.
Same order.
Same order.
State. Mr. Debra for the state.
Yes.
So the same order is being passed.
My lord.
Same order.
800, yes.
Petitioner.
Well, I am for the
I am
State.
appealing for. I am appealing. I am for the state respondent.
Yes. Yes, Mr. Shamantu.
The petitioner was a holder of a permanent stage gas permit, my lord.
Yes.
Petitioner was holder of a permanent stage gas permit. My lord, that permit has been cancelled without any opportunity hearing. My lord, you'll also kindly see, I have annexed the copy of the permit, my lord. You'll also kindly come to page 20, my lord. And representation is there, my lord, page 21. I pray, my lord, that the respondent number 2 may consider the representation after giving an opportunity hearing. Well, that's my prayer.
My lord, my respectful submission, my lord. This is complied. The respondent, my lord, complied with all the formalities before cancelling his permit. Lord, say allow me to, my lord, file a report to that effect so that, my lord, matter can be solved. Because it's a notified route. It is a notified route.
Was given an opportunity of hearing.
Yes. My specific instruction and notice has been given. Show cause notice has been given to him.
So please come back with a report in that case.
Yes, that is better.
My instruction is I was not given an opportunity for notice.
Let us see
I
the
made
documents.
Notice I have to produce right now. If Mr. Chamanto is here.
Not issuance, service.
Service I have to, my lord. I have to file a report, my lord. That is better. My lord, another thing, my lord, my submission is that, my lord, that vacancy is there. And in terms of the division bench order, presently, my lord, we have to publish before the
vacancy
before
notification. Yes.
before the, yes. So that, my lord, he can apply when the vacancy is published. That is better.
Very nicely submission.
Yes.
Where is the
Please-
bar
please
to
come back
consummate
with the report.
representation?
Mr. Shamantu doesn't agree to this. Please come back to the report with the report. The petitioner complains that his permit has been cancelled by the authority before without granting an opportunity of hearing to him. The petitioner submitted an objection in this regard before the authority on 9th November 2023, which is yet to be considered. Paragraph. Learned counsel for the respondent.
Malad, may I submit? Let it be considered. The authority decide.
Yes,
Otherwise,
that's my prayer.
The petitioner prays for a direction upon the authority to consider the representation at the earliest.
authority to take a decision, that is better.
Yes, yes.
Paragraph. Learned counsel for the respondents submits. Secretary or the board?
No, board, my lord.
Board, RTA board, my lord.
Second respondent be
Second
directed to
respondent.
consider the representation in accordance with law. Paragraph. In view of the above, the petition is disposed of, directing the second respondent to consider and dispose of the representation submitted by the petitioner dated such and such within 1 month.
No, my lord, board is not sitting due to election.
6 weeks.
6 weeks.
Within 6 weeks from the date of communication of this order, upon affording reasonable opportunity of hearing to the petitioner, comma, in accordance with law. Paragraph. The decision taken by the authority shall be communicated to the petitioner within a week thereof. Disposed of.
Mild.
Under the Motor Vehicles Act, there is no provision for cancellation review.
Yes, 86(1), Mr. Damanto. You are my you are my teacher. Why should I?
But there has to be an opportunity of hearing.
That is must be.
Next.
Well, I'm appearing on behalf of the petitioner.
I am appearing for the respondent, my lord.
I was holding a permanent.
My lord, my specific instruction, my lord, he's open his case, my lord, the renewal. My instructions yesterday also, my lord, renewal has already been made in the month of January. So, lordship kindly.
The month of January.
Renewal?
Client ke জিজ্ঞেস করো, Mr. Khan.
Yes, no.
Let them take a decision. Lordship kindly pass an order. Let them take a decision. If not, they let them take a decision.
The authority has not accepted my application. This is my allegation. Although initially, my lord, I holding a permanent contractor's permit in respect to route, my lord, Rajmath to Gopalpur. But
This is not renewal. This is
not the case of renewal.
This is not renewal. A
Not
fresh
the case of
permit.
renewal. This is not the case of renewal. Well, actually, my lord, I lost this permit, so I could not apply for my lord renewal of permit. Then, my lord, I made a representation before the authority, but to accept my application on another route, that is Gopalpur to Durgapur railway station. But that application was not accepted. Then I moved a representation before your lordship. Kindly see the page number 26. Page number 26.
The same vehicle. The same vehicle.
Yes, the same vehicle. Auto, which is the contract.
Auto rickshaw.
But page number 26. My lord was placed to pass an order directing on 13 September 2022 and directing the Secretary Regional Transport Authority, Paschim Bardwan, to accept my application and to take decision according to the law. Well, within the prescribed limits, because my several times I went to the office but did not accept the application.
So this order has not been complied
1 year less. So I could not scope for filing the contempt petition. So again, I requested the authority to make a fresh application, page number 28. Page number 28, requesting authority to accept my application on the route Gopalpur to Durgapur railway station. But according to section 88, any application for a car for any time may be made at any time.
Let this order be complied with within
Yes,
within
that
the
will-
time frame.
yes.
The
Lordship.
order has not been complied with.
My specific instruction, the order has been complied. Lordship kindly let it pass an order. That is better.
To accept my application.
Heard learned counsels for the parties. By an order passed on September 13, 2022 in WPA 19923 of 2022, this court directed the who was the fourth respondent
Respondent number 3, may
in
post.
the earlier matter?
Respondent number 4.
No, in the earlier petition, the secretary.
Yes, Secretary.
The secretary.
Secretary
Secretary.
Secretary RTA Paschim Bardwan.
Regional Transport Authority, Paschim Bardhaman, being the fourth respondent in the earlier being the fourth respondent therein, to receive/accept the application filed by the petitioner for issuance of fresh permit along with requisite fees. Along with the requisite fees আগে দিন তারপর for issuance of fresh permit করুন। Within a stipulated time frame. Stop. Paragraph, learned counsel for the petitioner submits that the said order has not been complied with by the authority till date.
My instruction, Lordship, kindly see.
Yes, I'll record. The petitioner submitted a further representation in this regard on 24th January 2024, which is also pending. Paragraph, learned counsel for the respondents submits that the representations submitted by the petitioner has been considered by the authority and permit granted in his favor.
That is my instruction, madam. That is.
ওটা করুন, submits comma on
I
instruction.
do not know what this.
It is renewed, not granted, that renewed.
Comma on instructions. It is a.
You have not applied for renewal of permit. You
Renewal
have
is
lost the
not applied
permit.
for, it's
You have
fresh
lost the permit for we have.
So Lordship can direct them. If not, they will consider. Take steps to
And-
comply with my Lord's order.
এত বলো। Permit issued in favor of the petitioner.
My lord.
Paragraph, in view of the above, the writ petition is disposed of, directing the fourth respondent to consider and dispose of the representations submitted by the petitioner in terms of the order passed by this court on September 13, 2022 in WPA 19923 of 2022 within 1 month, Secretary. Within 1 month from the date of communication of this order, upon affording reasonable opportunity of hearing
My lord.
to all concerned, including the petitioner, comma, in accordance with law. Paragraph, the decision taken by the authority shall be communicated to the petitioner within a week thereof.
Deeply obliged.
আচ্ছা, consider বললাম না, যেখানে consider and dispose of, ওখানে comma if not already considered.
Yes, madam. That is.
Petitioner, no, petitioner, comma, if not already considered. If not already considered, comma, but in terms of.
Deeply obliged.
Closed up, exactly.
Deeply
Next.
This is my matter.
I am appearing for the respondent.
One of the petitioner, as a permanent permit holder, the route is from Bodhanganj to Kolkata. Number one objection raised by an operator, by which the objections was directed to be considered by my lord. Lordship will find at page 18. With regard to the route which overlaps the person's route, Lordship's direction order was at page 18. A hearing took place, that is an objection, and it was my lord was directed the authority to consider the objection, giving an opportunity of hearing to all the parties. After that hearing took place, and it was the issue was there is a different one, but it was considered in the another aspect, and the order was passed. Now, page 20 is the order imputed. This is one of the someone suspicious that the vehicle which was operating on the permit issued by the State Transport Authority, that the
This is a prayer for replacement, but your prayer was different. You raised an
Because it
objection
is-
against overlapping.
No, myself not. There is an objection that was taken into consideration by the authority. On the basis of that order, your lordship will find that here, my lord, this writ petition number.
The objection was raised by you.
No.
No.
Your lordship will find that
Not the
Ananto
petitioner here. Yes.
against my permit, that which is overlapping there. Now, subsequent to my lord, on hearing, it is found by the authority that the vehicle which is operating on the basis of that permit, that has, my lord, the age limit of that is X month.
But this is not
More than-
consideration of the objection. This is an independent letter issued to you.
But that apart, what happened, my lord, thereafter, my lord, it is, my lord, your lordship will find that in the order itself, it's mentioned that the registration, it is not allowed to ply in KMA. My lord.
Yes.
Yes, sir. Now your lordship kindly come to next page. When the petitioner went to, my lord, the registering authority to pay the tax, now when it is found, my lord, there, they told this vehicle cannot be operated even outside the KMA. Your lordship kindly come to this page 20. Page 26. 26. And it has been blacklisted. Your lordship will find. That is on next. 25 is started and 26 middle portion vehicle is flagged as not to be transacted NTBT by Murshidabad RTO so and so due to reasons government decisions as required by the Secretary State Transport Authority West Bengal.
It is not blacklisted.
And that on the basis of the this was required, your lordship will find as required by the Secretary State Transport Authority West Bengal.
Requested by, yes. As requested by.
Means it has been requested, but without my information, nothing has been. When I went to the authority to pay the tax, these are registering authority. Now, my decision is that to the effect you cannot operate this vehicle in KMA. Now it is, my lord, it has been, my lord, issued by Murshidabad.
It is in terms of page 20. And page 20 is a letter issued to you.
Correct. That page 20, your lordship kindly see the page 20 is the letter by which I have been restricted from operating the vehicle. Your lordship kindly see.
And there is another letter, page 33. Memo number 33. This is 31.
Page?
There was another memo number 33. Yes, Mr. Debra, let there be a report, I think.
My lord. This is one 15 years old vehicle, my lord. Mr. Mukherjee also knows, my lord. He's a Kolkata, my KMA. He is starting from KMA. That is why this restriction is there.
But page 26 says not only KMA, he cannot ply the vehicle at all.
Natural 15 years old vehicle. I shall file a report. My lord, that is
Second issue is, my lord, after filing, my lord, today, my lord, this vehicle was requisitioned by the transport department
for election.
That is another aspect. That is not neither they are not there. That is not the
How
case.
can that be another aspect?
So it has to be, my lord, decided by my lord
Stop the
whether
vehicle
the
from flying and
yes,
you
my lord, whether
requisition the
15
new,
years vehicle
We cannot be. It cannot be requisition. That is when he is flying his vehicle. He is illegally flying his vehicle.
Let Mr. Debra come with a report. Please file this by a supplementary. I'll deal with it.
And he is flying his vehicle illegally. Lordship can record it. That is why my requisition.
The requisition is also illegal?
Yes, that is illegal. But he's flying also illegal. Without restriction is there. Why he is flying?
Affidavit of service. Learned counsel for the petitioner submits that by a letter issued on 29 January 2024 by the Secretary, State Transport Authority, West Bengal. The petitioner was
supplementary affidavit annexing that document.
requested to stop plying his vehicle bearing registration number WB 57 capital A 1735 in the KMA area since the vehicle was more than 15 years old. Stop. Subsequently, the vehicle has been flagged as inverted comma colon not to be transacted. Not to be transacted, not to be transacted by the Murshidabad RTO in terms of the request made by the Secretary, State Transport Authority, West Bengal in his letter dated 29th January 2024. একদম শুরুতে করুন, on prayer of the petitioner, liberty is granted to use a supplementary affidavit annexing relevant documents. At last stater পরে করুন, learned counsel for the state respondents seeks to submit a report in the form of affidavit in this regard. Paragraph, let the matter appear under the same heading on 17th April.
My lordship kindly appreciate this vehicle is, but if it is outside the KMA, then I could have applied.
No question of applying.
No, because I cannot, because your lordship kindly.
Point must be decided. Point must be decided.
Only take page 26 for a moment.
I've seen.
Page 26, at the the documents which valid up to 18th October 2024 fitness tax valid so and so. The lordship kindly say tax has to be 15th April is my tax to be expired 15th April. So prior to that,
Everything else has expired. Insurance has expired, the pollution has expired.
Insurance expired. Number PUC certainly March 26. Pollution and only two
Please
things.
come back on 10th April. 10th April.
10th.
10th.
No, 17th. 10th.
10th.
Only one thing, only one thing, supplementary affidavit which I prepared, advance copy may be given, because that's you could give the answer to that.
And I would request Mr. Devra also to serve an advance copy so that we can deal with the matter on the next day. Next.
He done that for Mala. I'm appearing, my lord.
Petitioner, Mr. Mukherjee.
Yes. To come to
ঘটনাটা বলো
during the panchayat elections, my vehicle was requisitioned. Number of vehicle is of my lord, registered in the state of Odisha. There it was requisitioned. Number of when the vehicle was released from the requisition, after the elections was over, when I going to back to my state, the vehicle was intercepted. And because of this reasons, it was also released at the moment. And the tax has been imposed. And then we also will find at page 22, a challan was generated. Order of petition. Now we are also kindly come to
Yes.
now we are also find at page 41. To gather the information
I made an application under Right to Information Act before the block develop page 41. Now your lordship will find my registration number of the vehicle and the reasons for which it was in the state, that also given there. In this regard, you are requested to look into the matter.
Page 43.
Page 41. Then this was not together. This was not replied. Then it was referred to the one after another. Authorities referred this RTI together to inform the petitioners in that way. That is not done. Subsequently, my vehicle was I then page 44. It was informed a representation made to the SDO contact, then taxing officer, then the motor vehicle inspector. And I prayed them that as because of the election, panchayat election, this vehicle was requisition, and after the election was over, when I returned back to my original state, vehicle was intercepted and a claim of rupees 2,70,046. Page 45. They claim this 2,70,045. Now, as I not received any information of my representation, I will also find at page 50. This is important. Page 50. Regarding compliance of the order dated 10/10/2020 passed by the আগেরটা তো বলতে হবে কেন করছি ফটোকে গেছি তো এটা পড়ে জানাচ্ছি ফটোকেটা আমি লিখতে বসবি সারাদিনে এনে
একদম
ব্ল্যাকলিস্টেড করেছিল সেটা কোথায় আছে কেনা কবে সেটা দেখালে ছোট
Yes.
it was as because I did not deposit the claimed amount, the authority blacklisted my vehicle again. Authority blacklisted. And I moved the vehicle as because the vehicle is registered with in the state of Odisha. I moved therein a writ petition. When I went to the authority to deposit the tax, it was shown that this was blacklisted to my state. Then I moved a writ petition before the High Court at Odisha, Kotak. There this order passed.
It was blacklisted in the earlier state.
Pilot.
It was blacklisted in Mayurbhanj.
It was by the state. There is. It was blacklisted by the state of West Bengal.
I'm coming, my lord.
Now, the lordship will find at page 35 the order of
Page 35.
page 35. The order of Odisha High Court at Kotak.
Yes.
Paragraph 4 of the order. In view of above, this court is of the considered opinion that unless the decision issued by the issuer means issued by the authority under the MV Act of the West Bengal. This is actually blacklisting of the vehicle.
অর্ডারটা দিয়ে আমরা
Yes.
Now, then I wrote to the
ডিসেম্বর 2027
now I wrote to the registering authority. That is at page 48. To registering authority, then additional regional transport officer Contai, who has intercepted the vehicle, and the motor vehicles inspector. Now we are also page 50. Though the registering authority, they have communicated that the reasons, but the other authorities never communicated any reason as to why it was blacklisted. The difficulty is that the tax which has to be paid even both the state, if it is operating on the basis of permit, have been injuncted to pay even the tax. There is
এখন পর্যন্ত ইন্টাক্ট কনসিডারেশন মধ্যে নেই এটা ওদের রিপোর্ট বারবার রিপোর্ট
হ্যাঁ
ফ্যাক্টরি তো কনসিডারেশন হয়
rather again
ক্যান্সেল করে দিয়েছি আমরা
চিঠিটা এতে অ্যানেক্স করেছে 11
তার আগে ওদের ডিসেম্বরে চিঠি আছে
Mr. Mukherjee, do you want to continue some other day? So they will have some other day. Affidavit of service. Third learned counsel for the petitioner. Paragraph of the matter appear on the same page. 17th April.
My lord.
Your lordship, kindly appreciate.
All the matters.
10th, your lordship, kindly appreciate 10th, your lordship. Another matter, is I have not yet started that time.
Very well, 10th.
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 কি বললো শুধু শুধু 10th আর কি
My lord, Mr. Mukherjee made out a good story. He has to write a letter because vehicle has been intercepted. When the my lord was passed an order, I am not telling anything. When the vehicle is stopped at the Contai first terminus with passengers or medical passengers going to Bhubaneswar Medical College. That is why on humanitarian ground, my lord, my officers release the vehicle immediately.
Will you come back with a report on the next date?
That is the lordship kindly give me time. 17th lordship come back, I shall file a report. That is better.
Yes,
10th.
17th is the holiday. As
Why?
per instruction of Mr. Challenge.
Why? What is there on 17th?
State government has
Has given.
No, government অনেক সময় দেয় আমাদের দেয় না গো।
I don't think the court closes.
I don't know, but NI Act always accepted by the High Court.
Any day, my lord, any day.
ওটা একটা লাইন অ্যাড করুন
Any day, my lord.
ওটার আগে করুন যেটা হার্ট করলো learned counsel for the respondents
Table.
seeks to submit a report in the form of affidavit in this matter. Paragraph, let the matter appear.
তাহলে আমি
ও learned প্রথম থেকে কি বললাম heard learned counsel for the হ্যাঁ heard learned counsel for the petitioner. তারপর learned counsel for the respondents seeks to submit a report in the form of affidavit in this matter. Paragraph, let the matter appear under the same heading on 19th in that case.
19th April. But then in the meantime, if
Yes, in the
What in the meantime?
আমাকে কিছু দিতে বলিনি, but you my learned friend.
Yes. I use report.
No,
Definitely.
Paying from my lord.
next hearing matters.
Develop. 839.
Petitioner,
First matter.
Mr. Mukherjee petition.
Very outset, but I should matters appear on several occasions.
Last chance has been granted.
My instruction. So Lordship, don't take it in a way. My instruction at the first, they filed the oppositions state. Long back, it is about March 2023. The orders has come in. Now, at that point of time, the petitioner instruction was that not to file the reply to the affidavit. Now, day before the last Friday, he started, I was not there. He started a junior that intend to file 1 week time to file reply.
Please
So,
start
Lordship,
your
I shut my mouth as your Lordship. Whatever your Lordship says, I cannot say anything.
I'll grant you liberty, but please commence your submission. Please start your case submission.
Unless
I will not grant any further adjournment today.
the only next day, your Lordship, and
I'll dismiss it today. Several dates, Mr. Mukherjee, I'm really so sorry. Several dates, no further accommodation can be granted. In the meantime, you can come back with a reply, but please start your submission today. Mr. Mukherjee is in trouble.
He is not ready today, my lord. Lordship kindly accommodate, my lord.
Learned counsel for the petitioner seeks to use an affidavit in reply to the affidavit in opposition submitted on behalf of the respondents. Paragraph, let the matter appear on the under the same heading. Hearing as on 23rd April.
My lord.
Sufficient.
But
Mr. Mukherjee, I will
in the
not
meantime,
hear
in
any
the
submission.
meantime, I file the reply.
Whatever
And will hand
you
over
are
my
doing
copy.
in the meantime.
I will file a reply, but I will serve the copy of the reply
No
on that day.
further submission on the next
No,
day. Don't I'll hear the case.
I will not.
Next.
Back to the petitioner.
See, this is a matter. This is a matter, Lordship will remember, with pertain to the cycles. Respondents, my lord, they sought accommodation on the previous occasion, and Lordship, this matter is pending since long. On the last occasion, and I placed my case, my lord.
You have completed your submission.
And
the
so far,
response
this is a matter, my lord. It's a car parking space adjacent to Shialda. Tender was floated. I appeared and
Miss Rama Mukherjee, who is
Rama, she is the advocate on record, my lord. And several occasions adjournments have been sought on behalf of her. Now, my lord, today, my lord, I need to at least let me complete my submission, my
In
lord.
absence of the respondents.
Because whatever I will say on the basis of the documents which is annexed in the writ
Because,
application.
Last two occasions it was heard.
Because my money is
Let us
lying with
come.
the railways, my lord. And
I understand, but today I do not find them.
because
They were
interim order,
there all throughout. Last two occasions they were there.
I should kindly make it a last
extended
chance.
interim
Because they have not seeking any accommodation, my lord.
I'll record that. I'll record that. I'll extend your interim.
Interim order, man.
None appears for the respondents. No
No.
accommodation is sought. Paragraph, let the matter appear under the same heading on
Very short date, my lord.
12th April.
12th. Interim
Paragraph,
order.
the interim order granted earlier is extended till 31st May or until further orders, comma, whichever is earlier. 31st May, bola, huh?
My lord, kindly make them that they should not take any further adjournment because already
Last two occasions they were there. So I
they were
cannot,
there, my lord. But they
I
didn't.
cannot record this in this order. Come back. Please intimate them. That will be
Because I have
safer.
seen her today and told that I will be doing this matter today. Now she is not appearing.
Please intimate her in writing
I will issue notice.
so that
Fresh
you can
notice.
produce it before the court.
My lord, in this matter, I am appearing on behalf of the petitioner. Matter was heard on several occasions. So, like my learned senior friend, my lord, appearing on behalf of the state. Or affidavit has not been changed.
By the-
matter.
By the private parties, my lordship. Petitioner and my lord, the private interested party. They change their affidavits, my lord, conflict of interest. We are only the umpire, lordship. Lordship.
But who is appearing for the private respondent? Mr. Shamanto. Where is he? He was here also.
Every occasion matter, several occasions matter for her. So one kind-
Why don't, he has been appearing all throughout.
Yes, they appear also.
Why don't you serve an intimation to him?
Can you see the
And he
previous
was here
order?
in the afternoon.
Several occasions, my lord, I made the submission. I prayed for time. Like I never prayed for time. So my lord, yeah, I have also. But I'm here. Now he has gone.
He was here.
Yeah.
He has missed it, I'm sure.
I suggested lordship on the very first day, my lord, let the issues be referred to, my lord, the
Authority. This is
authority to hear parties and to
Because
resolve
I-
the issue.
So-called notice was given, I given the reply.
I'll grant you a short date. Please intimate Mr.
Well,
Shamanto.
next fight, my lord,
Please
only
request
for
him
not
to
today.
be here.
Only for not today. But simple matter, only 5 minutes. I assure my lord,
Not today.
not today. Deeply obliged. I shall inform. I
Can be disposed of.
shall inform.
Other side, okay. That was name.
Not today.
I have for the petitioner, my lord. Pleadings are complete, my lord. This is a matter.
Respondents, what's wrong today?
Oh, yes, yes. My lord,
Yes.
ready?
Ready?
My lord, my learned friend may submit today, my lord.
I will
On the,
concise my statement within 10 minutes.
on the,
Thereafter, my lord,
my lord, on the next day I'll submit.
then Lordship, kindly give me 10 minutes. I will place my case.
On the next day I'll submit. Lordship.
Sorry, this is the matter, my lord. There was a tender in respect of one train of Mumbai Mail. I participated in the tender. I was selected as the highest bidder. Now, my lord, in terms of the tender conditions, I have to deposit security deposit to the tune of 50 lakhs rupees with the railways. Now, my lord, I started my operation. The originating station is Shalimar and the destination is CST. Now, my lord, after commencing the operation, I faced certain inconveniences. The rakes which are required to be placed at certain time, my lord, they were not placed on those time. There was a delay of several hours for which, my lord, I am unable to load the consignments. But at the same time, as a preconditioner, I have to deposit the freight charges. But that goes in waste. Now, my lord, another issue which I raised that sometimes they do not supply us with the parcel spaces. And now, my lord, I made a request. I continued with that
You
difficulty.
have suspended operation.
I have suspended the operation with a notice to them, and Railways has corresponded me. So she kindly come to page 113. 113, my lord, I made a representation prior to that, highlighting my inconveniences, and railway reciprocated by saying, in reference to the page 113,
Yes.
in reference to the above subject, it is to intimated that this division has leased out the parcel 1 LVH by train number such and such to Mrs. Moonline Express Cargo Private Limited for a period of 2 years with a contract value of 24 crore 42 lakh 76,815. Now the concerned leaseholder, while under their letter dated 10 of May 2023, has put forth their grievance, which is self-explanatory, and the same is briefed herewith. As per concerned leaseholder, the train is usually running late by 8 to 10 hours in both directions, along with further delay by 8 to 10 hours during the handling the VP at Shalimar, which leads to overall 24-hour delay, resulting to deterioration of the perishable consignments. Hence, it is hereby requested to look into the matter. If any such delay has been occurred due to operational reasons and within the divisional control, then the same may be tried to be resolved at the earliest, as well as request for early placement of VP at Shalimar for unloading may be considered. In addition to that, if any grievance pertains to operational constraints finds in their letter by the above, then the same may be also considered to be resolved. Now, my lord, they have acknowledged it. Now, my lord, even after acknowledgement, my lord, kindly see the next page. Railway, my lord, this is a letter which has been issued, which says that that particular train is permitted to run on 14/5/2023 without leased VP, since incoming train is running 15 hours late and plan to run such and such from. My lord, I have been not being provided a leased VP also. This is how they have dealt with this situation. So I have suspended the operation by writing a letter to them. Now, my lord, I apprehended termination. That is the reason I approached before this honorable court. This honorable court, my lord, please to at least pass a direction that not to take any coercive measures. Now, in the meantime, lordship, they filed their affidavit in opposition. In the affidavit in opposition, no endeavor has been made to resolve these issues. Because until and unless I load the consignments, then it is not at all possible for me to do the business. And to show my bona fide, I have secured the railways with rupees 50 lakhs as security deposit that is lying with them. So either they have to resolve this or they have to return my security deposits. But they have not taken any steps so far as the affidavit in opposition is concerned, my lord. They are saying that you have to operate come what may. Others are operating in different trains. So there is no difficulty on your part to continue with the same. So if this be the situation, my lord, at one hand, they are saying that we will resolve it. Another hand, they are issuing threatening statements. So for this reason, my lord, there is a clause. If I lordship can show your lordship the clause at page 93. If the issue cannot be addressed in that proper perspective, then there is a clause which says 17.2. that the railway administration shall have the right to terminate the contract agreement without any financial repercussion on either side for any reason whatsoever after serving 1 month's notice to the contractor. Railway shall also reserve the right to terminate the contract with immediate effect without any financial repercussion on either side in case of operational exigencies or in case where the assets for which the contract was awarded is not available for commercial exploitation due to some other developments or change in site or any other reason. Full EMD or SD and lump sum freight rent license fee paid by the contractor shall be refunded to the contractor without any interest. My lord, this is the clause, my lord, which empowers the railways that if they are not in a position to address my concern, then in that case, they can invoke this clause and they can return the security deposits. Because I have deposited the security deposit with an intent to do business with the railways. It is not that I have deposited security deposit without any reason. I have made them, whatever the condition is saying, that I have abided by that. There is no breach on my part. Because had there been any breach, they would have highlighted that before in their affidavit in opposition.
That's not being done.
Now, there is apparently no breach. So, my respectful submission will be, my lord, at taking into account the affidavit in opposition, my lord, they have stated that they will terminate my contract. Page 17.
of page paragraph 12. Page 12, my lord, paragraph 17.
Yes.
It says that with reference to the statements made in paragraph 25, the writ petition, the grounds made therein, all are vague. And I further say that placement of VPH is continued, so non-loading would lead to forfeiture of lease, freight rate, or due as per clause laid down in the agreement, but the petitioner suddenly stop the loading, and if it is continued, railway may take legal action for termination of the contract. I am protected to that extent. But my lord, not a single whisper has been made in the affidavit in opposition. The opposition is there before your lordship will see that not a step has been taken in the positive direction to address my concern. Because they have acknowledged this issue and they have stated that they will resolve this same. But if they cannot address my issue, then they have to refund my security deposit. Because considerable time has gone by, my lord. They are not before your lordship with any report or any paper which shows nothing in this. Now, no documents have been annexed here to show that they have taken any steps to address my concern. So, my lord, in that case, my lord, direction may be issued at least to refund my security deposit. But if they do not want to sort the issues as they have stated, then possible response should be made.
That's all your submission.
That is my submission.
Please take necessary instructions.
Yes, yes,
You have to resolve the issue.
yes, yes,
This
yes,
blame game will really not help, isn't
yes,
it?
yes. I will talk to them and
Your affidavit says that the petitioner has to continue under all circumstances. That is not possible.
yes, yes. I will take instruction and my lord, I will.
My lord, instruction should be within the parameter of the opposition. Now, in the opposition,
No. What they have taken at present moment that
They can resolve the issue.
Yes,
then
yes.
Why not?
let the lordship,
Then you come back with further
instruction
Yes, yes.
with regard to lordship, kindly one line direction at least. If they cannot
writ
resolve,
petition of writ petition of the year 2023. Now we are in 2024. My lord, that I am telling my lord before your lordship, my lord, I have to take instruction whether they have
but already
resolved
they
or
have
not.
done affidavit in opposition.
Yes, yes. That
And in the opposition itself, it is silent.
I'll not record any direction. Let them come back. Let us see. What
yes, there is
And in that case, my
interim
lord,
order.
kindly extend the
I
interim
will-
order.
I will. Ordered counsel for the petitioner. Paragraph on prayer of the respondents. The matter is adjourned. Paragraph, let the matter appear under the same heading on 19th April.
Lordship.
Paragraph, the interim order granted earlier is extended till 31st May or until further orders, whichever is earlier.
Wait,
31st May. Next.
Well, this is the matter. Lordship may recall, this was Lordship was inclined to dispose of on the first day itself, where Rule 10B of the telegraph rules provide 2022 or 2023 rules.
Appeal for the respondents.
Mr. Tonav Chakraborty appeared.
Lordship, I am appearing, Advocate Rashmi Bothra for the Union of India, Your Lordship.
What about the state? Anyone for the state?
So there was urgency from our side because we are the telegraph operators and we installed
Shall I
towers.
make it only not today? Will you inform the state?
Or she
so that
kindly
we
make
can-
an order so that we can inform and we can at least ensure they come tomorrow.
Not today means it will appear on.
I know that, Lord Lordship, if you can make a one-line order, then it will be
So I have to
easier.
give a date in that because I cannot give such a short.
No, very well. Let it be tomorrow in that case, madam. We shall give them
That's
notice.
why I said no.
We shall give them a
Please
notice.
inform the state so that they are present. No, not today.
This is the last one. What do you want? This is the last matter he is saying in group 7.
Very few matters, isn't it?
As mine.
দেখি কোথায় মাঝে লিস্টে দিন এই কর্পোরেট দিন যেখানে
Pending. What is the challenge in the application? Should I just put it?
Yes, monthly list.
May it please your lordship. This is my petition. Affidavit is a complete lordship would find
Who is appealing
since
for the respondents?
yes, since July 14, 2023 till November 28, 2023, at least 4 times, my lord, accommodation was prayed for on behalf of the respondents. Lordship has been pleased to grant. On the last occasion, Lordship was pleased to direct us to serve them again. We have, my lord, prepared an affidavit of service, my lord, except the respondent number 2, my lord, all the other respondents, both Union of India as also the railways, my lord, it has been served. Lordship would kindly.
You have not served all of them.
2 has come back, my lord, with insufficient address.
So why don't you complete service and come back?
Lordship would, may I, my lord, just Lordship
Because
kindly.
learned councils were there on record. Why don't you serve the learned councils
They have not been appearing in
instead of serving the parties?
Difficulty is this, my lord. I will tell my lord difficulty is. The difficulty is, at least on 3 occasions, my lord, different sets of councils have appeared. That was really the reason why they had prayed for accommodation. Lordship would find.
Serve the last person who was appearing. That will be easier, isn't it? It was returned with insufficient address, you are saying.
Only the respondent number 2. And respondent number 2, Lordship would find.
2 is the chief commercial manager.
Yes. But other than that, my lord.
So there are other Southeastern Railways.
Yes, railways have already filed affidavit. Union of India did not file. Now, Union of India has been served. Respondent 1 has been served. 3, 4, of course, have been served. So 2, 3, 4 is together, if I may, my lord, say so.
They have also filed their
Please inform the learned councils. I'll record that the matter will be taken up even in their absence on the next occasion.
Good.
Let that be recorded.
Yes, yes, that much, my lord. May I, my lord, file my affidavit of service?
Affidavit of service. None appears for the respondents. Stop. No accommodation is sought. Paragraph, let the matter appear under the same heading on 23rd April.
May it be a bit earlier, subject to lordships also.
Matters. 19th, I've just fixed the matter. Anyway, 19th April. 19th April. Karan. Paragraph, it is made clear that the matter may be taken up for consideration on the adjourned date, even in absence of the respondents.
Great. I will inform on it. Great. Much obliged.
Please, I'm not giving
No,
you
no, no,
directly. Please inform the respondents.
Of course I will. Of course. This out.
I am for the petition.
I am for the added respondent.
I want to take care. Your lordship has given the passed the interim order in my favor until further order. Last time it was made until further order. And
Other respondents.
when a respondent is state is Mr. Niladri, Himadri.
The Shantanu Maitri,
Shantanu Maitri.
he is not in the panel, right?
No. Now he has already.
Panel?
Yes. With high responsibility. Previously he was junior competent advocate. Now he is.
2023 he was appearing. Yes.
Yes.
The last occasion he didn't appear.
Last occasion he was not in the panel.
Yes, on 12th December.
Exchanged.
State has given
Your
the report.
is not there.
He has not given any
You
report.
want to use.
No, I want to use my lord. Kindly give me 7 days time, my lord. I shall file.
On the earlier occasion also you
Yes,
not
yes.
time.
I am very sorry, my lord.
The state has used affidavit.
No.
State has used means state has given a report in the form of affidavit. Not the affidavit in opposition. So far I remember correctly. Right?
State has not filed any opposition, my lord. They have only filed a report in the form of an affidavit. Thereafter, we
Appears
made
for the state respondents. Stop, no accommodation is sought. Paragraph affidavits in opposition affidavits, Govind. In opposition are yet to be filed by the respondents. Paragraph, let the matter, will you inform the state in the meantime, Mr. Chatterjee?
Yes, yes.
Let the matter appear under the same heading on 23rd April.
Deeply.
Order to